Order. We now come to the debate on lawfare and the UK court system. Before I call the right honourable member to open the debate, I should inform the House that the Speaker has authorised a waiver under the terms of the sub judice resolution to allow reference in this debate to certain cases which would otherwise be subject to that resolution. This is because the issue to be debated relates to matters of national importance. The right honourable member is aware of the cases covered by the waiver. I call David Davis.
Thank you, Mr Deputy Speaker. I'm grateful to Mr Speaker for issuing a waiver in this case. Of course, I recognise why it's important that members of this House do not seek to influence the outcome of cases before the courts, and if these were matters before a jury, I would be wary about raising them myself. But these matters are matters of national importance, and I'm grateful for the opportunity of raising them. We are rightly proud of our legal system in this country. Britain is home to some of the fairest and best courts in the world. Centuries of jurisprudence means London is amongst the most respected cities from a legal perspective. However, what is attractive to legitimate businessmen is also attractive to those with nefarious intentions. There are those with exceptionally deep pockets and exceptionally questionable ethics. These people use our justice system to threaten, intimidate and put the fear of God into British journalists, citizens, officials and media organisations. What results is injustice, intimidation, suppression of free speech, crushing of a free press, bullying and bankruptcy. It results in protection from investigation and gives encouragement to fraudsters, crooks and money launderers. It has turned London into the global capital of dirty money. In extreme cases, it can undermine the security of the state by allowing people to act as extensions of foreign powers. This is lawfare. Lawfare against British freedom of speech, lawfare against the freedom of the press, and lawfare against justice for our citizens. Lawfare is the misuse of legal systems and principles by extraordinarily rich individuals and organisations to destroy their critics and opponents. In many cases, our reporters face reputational and financial ruin in defending themselves from these malevolent cases. And even if these cases are won, the expense and impact is huge. The chilling effect on a free press is extraordinary. Some newspapers hesitate to cover certain topics, such as the influence of Russian oligarchs, for fear of costly litigation. And in at least one case I know, the publication avoids the subject outright. These sorts of cases, designed to silence criticism, are so prolific that they now have an acronym, SLAPS, which stands for Strategic Litigation Against Public Participation. This type of lawsuit is based on laws on defamation, privacy, data protection, and, ironically, harassment. In the UK, the cost of defending a case, no matter how well sourced and no matter how great the public interest, can run into millions of pounds. These cases are so time-consuming and so costly, as the disclosure process before trial can be dragged out by deep-pocketed claimants for years, to financially hobble the defendant, even before they get to the ruling. It's not just the financial and reputational damage inflicted by these cases, lives are also being destroyed. Defendants are unable to work. Every waking moment is spent looking over their shoulders, wondering who or what is just round the corner. This is not about legitimate recourse against journalists making mistakes, because, as we know in this House, they can and they do. It's about shutting down scrutiny through fear. Early in 2021, Russia opposition leader Alexei Navalny published a video investigation into President Putin's palace on the Black Sea. In the video, he waved a copy of Putin's People, written by Catherine Belton, a much respected Financial Times journalist at the time. Just 2 months later, Belton and her publisher were suddenly served with a series of lawsuits filed over the course of 6 weeks by 4 Russian billionaires and the state-run company Rosneft, which I think gives it away that the Russian state is involved. Media lawyers with decades of experience in such cases said they'd never seen such a legal onslaught of such scale and intensity. These cases dragged on for over a year, yet the cost for that year alone ran into the millions, £1.5 million for Catherine Belton alone. If the case had gone on, it would have cost millions more. One of those suing, the final one that was suing Belton, was Roman Abramovich, the multi-billionaire owner of Chelsea Football Club. Abramovich claimed that Belton's book alleged he had a corrupt relationship with the Russian president and was making payments into Kremlin slush funds. An identical suit was also filed in Australian courts by Abramovich to effectively double the cost of defending the case and to further intimidate HarperCollins. It's worth reminding people of Mr. Abramovich's background and the character of the man. We're speaking here of the man who manages President Putin's private economic affairs, according to the Spanish National Intelligence Committee. This is a man who has refused a Swiss residency permit due to suspected involvement in money laundering and contacts with criminal organisations. Abramovich was also deemed a danger to public security and a reputational risk to Switzerland. Abramovich initially came to the UK on an investor visa in 2015. In 2015, the Home Office tightened the rules around these visas so applicants could be required to prove the origins of their wealth. In 2018, when his visa was up for renewal, Abramovich withdrew the application. When he bought Chelsea SC, Abramovich was the governor of Chukotka region of Russia. It's alleged by associates of his that the purchase was done at the behest of the Kremlin. As a result of the purchase, he now has enormous soft power and influence in the UK. I ask the House to come to their own conclusion that whether this man is acting at the behest of the Kremlin or Putin's government. Belton's case is now settled, and interestingly, there was a huge spin about it to suggest that Abramovich had won hands down, and he hadn't, but that's another matter. But for her colleague on the Financial Times, Tom Burgess, the author of Kleptopia, How Dirty Money is Conquering the World, his legal battles are just beginning. Burgess is being sued by the ENRC, the Eurasian National Resource Corporation, a privately owned Kazakh multinational mining company. Since April 2013, ENRC have been under investigation by our Serious Fraud Office for fraud, bribery and corruption. The investigation is one of the longest running and most complicated cases the SFO has on its books. This case and its reporting has prompted a wave of legal proceedings by ENRC in the United States and the UK against journalists, lawyers and serious fraud investigators. In May 2015, two former employees of ENRC turned up dead on the same day in a Missouri hotel. They were due to be witnesses in the SFO case. The cause of their death was recorded as malaria, but the chances of two people dying on the same day and the same time, broadly, within hours of each other from malaria is vanishingly small. The next year, a geologist associated with the company was found dead in the back of a burnt-out Audi in Johannesburg. Burgess outlined these facts in his book, but he's now facing the wrath of ENRC, who allege passages in the book are untrue and highly damaging. The reason? ENRC interpreted the reporting of the deaths as Burgess suggesting murder to protect its business interests, or alternatively, there are strong grounds to suspect that ENRC had been murdered. Now, even given the waiver, Mr. Deputy Speaker, I should not comment in the substance on the ongoing legal proceedings, but what I will say is that the FBI takes these allegations seriously enough that they are now investigating the Missouri deaths. So take from that what you will. Amazingly, when the FT reported the FBI's action, the ENRC then took action against that paper. So what do we now understand? That journalists are not allowed to publicly report the deaths of witnesses for fear that someone may deduce that they are murdered by a company like ENRC? I will give away another time.
I thank you for making a fantastically important speech, and I look forward to joining him to talk about these many subjects. What does he think about those UK-based, those London-based law firms that are so willing to sell a sort of intimidatory legal threats as part of their services?
Well, I think my honourable friend lights upon a very important point. It's very clear that some London-based law firms have found, as it were, an incredibly profitable niche that they're willing to pursue without too much concern about the outcome, and I think the professional bodies for those law firms ought to be looking very hard at them, as well as, of course, as the government. So it's a very important point, which I'm sure others will develop, of course.
And for giving way, he's making an absolutely excellent speech. Just on this point of the lawyers who are facilitating all of this army of lawyers doing the dirty work of the Russian government and oligarchs and other governments of other hostile regimes, would he agree with me that if we were to introduce a Foreign Agents Registration Act in this country, that lawyers acting on behalf of these people should actually be included in such a registration process?
An important and very persuasive point, but the truth is I suspect there are other people in this room at the moment. I'm looking to my left here, who are probably got stronger authority there than me. But what I'm trying to argue today is that this is an issue that requires government action. That government action will involve a whole series of things, from perhaps reorganising how civil cases are dealt with, through how we license private investigation, through the sort of things he's talking about, the foreign agents reporting arrangements. So it's a whole area which the government will have to take on in toto. Now, the assault faced by Burgess, HarperCollins, the FT, Serious Fraud Office and others has been described by a coalition of organisations as a form of legal harassment used by those with deep pockets to silence journalists. That same coalition is, and I quote, deeply troubled by the chilling effect of this wave of legal action has on legitimate investigative and anti-corruption work by journalists, law enforcement officials and others. And it's not just the financial costs, it's the emotional toll that this takes on those targeted. And sometimes it doesn't stop there, and this comes to the point the Honourable Gentleman raised. Lawfare is often buttressed by other methods of harassment and intimidation. John Gibson, a former Serious Fraud Office case controller, was sued by ENRC for allegedly leaking information to Tom Burgess, the journalist. Why did ENRC suspect this? Well, in cross-examination, ENRC's lawyer described in detail a meeting between Burgess and Gibson, a meeting that both had gone to extreme lengths to keep secret. It was organised over an encrypted message service and held in an underground car park with no telephone signal. So the only explanation of how ENRC's lawyer had details of the clandestine meeting would be if Burgess, Gibson, or both were being actively watched. That's a private company putting a journalist under aggressive surveillance. A private company putting a serious fraud office employee under aggressive surveillance. A private company, in essence, attempting to undermine the freedom of the press and frustrate the legitimate workings of the state. It's immoral, it's intimidating, it's unethical. Frankly, the entire industry needs to be looked at and powers put in place to tame the Wild West of private intelligence work. But it's not just journalists who are targets for this kind of bullying, and it's not just international billionaires. Our former colleague Charlotte Leslie, the Director of Conservative Middle East Council, is facing legal challenges from multimillionaire Mohammed Mercy. Court documents outline how Mr. Mercy tried to pressurise his way to becoming chair of the Conservative Middle East Council. It's been suggested that this was because he saw it as a route to a knighthood or other honour, and Miss Leslie rejected Mr. Mercy's attempts. In response, he tried to form his own group, the Conservative Friends of Middle East and North Africa. Miss Leslie then compiled a due diligence note on his background and was sent to Conservative quarters by Sir Nicholas Soames, the then chair. That memo outlined some details about Mercy's past, his associates and his dealings in Russia. It was compiled, as far as I could see, from open source research. Mr. Mercy got hold of this memo. In response, he had his lawyers send demanding letters to both Soames and Leslie. He claimed the memorandum was defamatory and inaccurate. However, despite this issue rumbling on for over a year, he only filed his defamation case last month. In the meantime, he used data law to take Miss Leslie to court, a growing tactic for those using slaps to silence their critics. In November, Miss Leslie appeared in the Royal Courts of Justice. The contention was that she had not responded properly to data subject access requests from Mercy. Usually, the Information Commissioner deals with such disagreements. But if you're a rich man who wants to silence and destroy someone, it goes to the courts. The claim was dismissed, and Charlotte and CMEC awarded 65% of the costs. But Mercy is bringing a claim back, and a 4-day trial has been scheduled for the spring, further ramping up enormous costs. So who is Mohammed Mercy? On his website, he describes himself as driven by a desire to create a world that's better for everybody. Let's test this, shall we, against public domain facts. In 2005, he made £4 million helping a Luxembourg company to buy a Russian telecoms business. The following year, a Swiss judge concluded this Luxembourg company was secretly owned by a top crony of Vladimir Putin, Leonard Riemann. In 2006, Mercy was also accused in a separate lawsuit of trying to extort a £2 billion payment, not on behalf of himself, but on behalf of a Russian oligarch. 4 years later, in 2010, Mercy advised on a transaction in Uzbekistan that was found to be a $220 million bribe to the daughter of the country's brutal dictator. When he was embroiled in a dispute in the early 1990s, a UK High Court judge described his conduct as lamentable, and his evidence as unreliable, unconvincing, and unsatisfactory. All of this information is available from public court records. Now, I cannot make an authoritative judgment on the matter, so I'll leave it to the House to decide for itself whether this served to create a world, quotes, better for everyone. And in his latest instance, Mercy has used his wealth and influence to try to bully Charlotte Leslie into silence.
Will my right honourable friend give way?
I will, of course, give way.
I'm grateful to my right honourable friend, and as a former colleague of Charlotte Leslie, she has been treated appallingly just for doing her job efficiently and in good faith, and I'm glad that he has exposed the appalling tactics that have been used against her. But is there no way of stopping repeated legal actions or threats of legal actions being brought? Because it's that attrition effect, which are clearly vexatious complaints, in order to intimidate people into submission or silence or effectively bankruptcy as well. Surely there should be some measure that says you have one shot at it at best, and then there's no further recourse to the courts or such legal action. Would that be a way of stopping this appalling actions that he's been describing?
Well, I agree. My honourable friend makes, my right honourable friend makes an extremely good point. But the way this happens is, first off, you have legal firms who now specialise in this, in making this sort of intimidatory tactic work, and of course it's based on multiple different laws. Now, as I said earlier, on everything from defamation to data protection and privacy. And therefore we have to find a way, I think, of the way the courts work, in governing the way the courts work, to make sure that exactly what he says doesn't happen, that you don't have multiple attempts. After all, you're going to be charged once for a crime, so why should you be sued multiple times for some other sort of misbehaviour? But it's not just Mercy who's engaged in this bullying and egregious behaviour, and again, it's not just law, because take for instance in this case Mr. Carl Hunter. Mr. Hunter was in contact by phone with Miss Leslie to attempt to informally broker peace between her and Mr. Mercy, and to urge her to apologise. And he told her that she needed, and I quote, to consider her position as being able to walk the dog at night and sleep well at night. You're looking at a world of pain on this. Clear and unacceptable threats, of which recordings are available, made an attempt to intimidate, and those recordings show other rather sinister comments as well.
You give way, by the way.
I will give way.
Just to reinforce the point that I think probably others are going to make, that while the lawyers, the Carter Rucks and the Michon Derers and all these other people are going to say everything that we do is legal, this is actually part of a really corrupt and intimidatory practice that veers well into the criminal as well. Even if the lawyers are obeying the law, there are other parts of these sorts of campaigns which frankly are purely criminal.
I take my honourable friend's point. He will understand I'm picking my way carefully through this, given Mr. Speaker's ruling on this, so as not to trip into trying to preempt the case. I'm just trying to present facts to the House so the House can make its own judgment. And it's not as if Charlotte Leslie has not tried to settle the issue after this intimidatory approach. She agreed to apologise to Mr. Mercy, and he rejected that. He's used to getting his way. He justified the use of money to get access to the royal family and members of the royal family as access capitalism. That's his word, his phrase. He has taken the same approach in this case. He throws money at a problem in an attempt to make it go away. Whilst Miss Leslie has been subject to this legal harassment for a year now, Sir Nicholas Soames has avoided the brunt of a Mercy's attack. Why? And this is not, by the way, a comment against Sir Nicholas, he's a very good man. But why has a Mercy not gone after Sir Nicholas? He says, in his own words, because of, and this is rather odd English, because of his grandioseness. He's not gone after Sir Nicholas Soames because of his grandioseness. Charlotte, on the other hand, is seen as not violent and therefore fair game. And there's a simple non-legal word for that. That's called bullying.
Yeah.
And that's what we're seeing here.
Absolutely.
So what do we need to do about slaps? Now, the members of this House have many more ideas than me. Many of them are much more skilled and knowledgeable than me in these areas. But the clear fact is it needs to be an issue of balance. Dealing with slaps is an issue of balance. It's not wrong to sue journalists. Sometimes they make serious mistakes or behave maliciously. But billionaires and multimillionaires should not be able to use the law to shut down legitimate criticism. Even if you defend your case successfully in this day and age, you face material costs so huge they will further deter others from following the story and can even destroy lives. Just to go off on a tangent, Charlotte Leslie, if she has to meet the costs of all of this, will probably have to sell her home and lose all her savings. And that's what an ordinary person faces in this context. In the United States, 31 states have passed anti-slap laws offering varying degrees of protection. Remember, they already have First Amendment. But in some cases allowing journalists and media organisations to file motions to dismiss such suits at an early stage on grounds that the case involves protected speech on a matter of public interest. Such a protection does not exist in the UK, enabling the process to be dragged out at great expense to both parties. It's fine for those with deep pockets, but for an ordinary person this is immensely damaging financially and emotionally. It destroys the entire concept of equality under the law. Other countries are already addressing this issue, and as they do, the problem for London will only grow as more and more ultra-wealthy individuals come here to exercise lawfare. So if London is to remain the envy of the legal world, then we need to get a grip on this problem and stop this rampant abuse of our system. If we do not, we will continue to face these kinds of attacks on the freedom of our press, the foundation of our state, and we'll leave our people subject to grotesque injustice in the face of this outrageous lawfare.
Yeah. The question is, as on the order paper, Liam Byrne.
Thank you very much, Mr. Deputy Speaker, and it's a real privilege and an honour to follow the right honourable gentleman to help open this debate and to follow on from his arguments. Mr. Deputy Speaker, follow the money is the oldest and wisest advice given to journalists who are pursuing the corrupt, shining lights where they need to be shone, and hunting the truth. Yet this dictum which has served us so well since Watergate, is now being smothered, suffocated and strangled in courts by allies, associates and friends of President Putin, who is pursuing a hybrid war against the West and against us. That is the context for this debate that we are moving this afternoon. Now, many of us in this House have been warning for some years that it is time for this country to wake up to this new threat. Hybrid war is a novel kind of conflict. Once upon a time, wars were fought on land and in the air and on sea. No more. Hybrid war is a battle for minds as much as it is for land, for influence and narrative, not simply territory. And that means it extends the battlefront to space, to cyberspace, and now to law space. It is fought with tweets as well as tanks, and now it is being fought with writs as one more weapon in the armoury. And of course, the reason for this is simple. What totalitarians, what autocrats, what kleptocrats fear most is the truth. And so what they are seeking to do is to murder the truth, and we are letting them do it in English courts. I give way to the Honourable Gentleman.
Friend, he's making an excellent speech, and I congratulate him on this debate. Just on this point of cyber and hacking, is he aware of cases whereby these Russian-backed interests are hacking people's private data, leaking their private data, and then suing them for libel? And does he agree with me that that is an utterly absurd and unacceptable position to be in?
My honourable friend is absolutely right, and I will come on to that in a moment, because the truth is that the truth is under attack by oligarchs with Russian connections, because what they are seeking to do is to disguise the origin of their fortunes, their methods of business, and of course their networks of friends. But the result, Mr. Deputy Speaker, is that the front line of this hybrid war now stretches from the streets of Donbass and the Crimea to the troll farms of St. Petersburg to the law courts of Britain, our courts in England, here in London. It was the Intelligence Select Committee, whose distinguished chair is here this afternoon, that made clear in its landmark report on Russia on page 22, I believe, that the interests of Russian business are now so closely entwined with the interests of the Russian state that it's impossible to unravel. But it is these honourable folks who are now using English courts as their preferred location for the business of truth silencing. In a survey of 63 journalists in 41 countries, there were more cases brought against journalists in the UK than in America and Europe combined. And as the right honourable gentleman said, the US and Europe are now moving to shut this down, and so that is why we are now becoming the capital, the global capital of the lawfare industry. So there are now so many cases that what we can reveal this afternoon, and it was evident in the right honourable gentleman's speech, we can now reveal what you might call the Oligarchs Playbook. Step one, target the individual, not the organisation, because it's the individual who is most vulnerable, and take aim at the slightest error. So, Aaron Banks did not go for The Guardian or The Observer, he went for Carol Cadwalader, and he took aim at a single sentence in her TED Talk. ENRC, as we've heard, has gone after Tom Burgess personally after he flagged witnesses to their crimes were being murdered. Paul Radu, who happens to be Romanian, is being pursued in English courts by corrupt Azerbaijani politicians. So we've got to ask, why are powerful interests from far away suing journalists who are not English and who do not write in English titles? Why are they being sued in English courts? Surely that has got to tell us that something in our country is going badly wrong. Step two is to maximise intimidation, if necessary, using covert surveillance. So, as we heard, investigators are now and journalists are now being inundated with data subject access requests so that people up to no good can basically smoke out what the investigators are actually up to. As we heard, ENRC agents actually surveilled Tom Burgess in a meeting that was actually arranged on an encrypted messaging app. How on earth did they know about that? The Financial Times journalist Dan McCrum, who actually helped break the Wirecard story, was subject to online abuse, hacking, electronic eavesdropping, and physical surveillance. Now, the point is, Mr. Deputy Speaker, these people now know no boundaries. They are completely out of control. At one stage, I've been told, Elizabeth Benham, who was the information commissioner at the height of the Cambridge Analytica scandal, was warned by counter-terrorism officers that MI5 had evidence that she was under active intrusive surveillance ordered by Mr. Aaron Banks, and so her office had to be swept. Others, as we've heard, have told us about the hack and leak technique, where systems are hacked into, information is then leaked to serve then as a trigger for defamation proceedings. Step three is then to file the most ludicrously exaggerated claims. So Mr. Abramovich's attack on Catherine Belton took completely out of context what Ms. Belton had actually written. We know that Tom Burgess has been attacked because he is alleged to have said that a corporate entity actually ordered these murders. The extraordinary exaggerations and twisting of what is actually written. Step 4 is then to coordinate the claims with others to maximise intimidation and indeed legal costs. So Catherine Belton was subject to this onslaught, first from the Alpha Group, then from Abramovich, then from Mikhail Friedman, then from Shalva Chesgurinsky, then from Peter Avon, and then from Rosneft. And we are being invited to believe that somehow this was uncoordinated. They must think we are complete idiots. And then step 5, as we have heard, is to file claims in multiple jurisdictions, like Mr. Abramovich's suit against HarperCollins in Australia, again, to maximise the cost against journalists, writers, and their publishers. So the impact is to create legal bills that are so big they chill and kill the truth. Catherine Belton's case cost well over £1.5 million. It would have cost millions more if it had gone any further. Carol Cadwallader's case is costing hundreds of thousands of pounds. Major Karpov's case against Bill Browder left Mr. Browder with a bill of £600,000, which the plaintiff hasn't paid because, lo and behold, when he lost his case, he subsequently just disappeared. So the result, Mr. Deputy Speaker, is democracy's watchdogs are having their tongues cut out and our writers are having their writing fingers now broken. The result of this is that suspicion multiplies and the risk of corruption grows. So I'm so glad that the Right Honourable Gentleman put before the House details of Mr. Mohammed Mercy as a case in point. I shared with the House on Monday, Mr. Deputy Speaker, intelligence sources that have been shared with me from sources inside the Kremlin and the Russian government. That includes information about one of Mr. Mercy's business partners, a man called Leonard Bogdan, who sources tell me has, quote, a definite FSB background. I now learn that Mr. Bogdan's daughter works for the Conservative Party Central Office and indeed, ironically enough, surprise, surprise, was briefly secretary of Comina. We then learn, as the Right Honourable Gentleman said, Mr. Mercy's associate, friend, colleague, lunching partner, Carl Winter, threatened a former Member of Parliament, Charlotte Leslie, that without an apology to Mr. Mercy, the case, quote, had all possibility of going further to a really gruesome stage, unquote. What on earth is going on in this country when people like this are able to issue threats to anyone, never mind former members of this House? And still Mr. Mercy thinks that he can go to a 4-day trial next year and take Ms. Leslie to court. We still don't know the origin of Mr. Banks' donations into Leave.eu, and when the Electoral Commission warned about the poor National Crime Agency investigation, Mr. Banks then sued the Electoral Commission and forced them to take down a statement about his lies. We've heard from regulators who fear judicial review because they fear the subject access requests that might come in from representatives of organised crime groups who are seeking banking licences. This is madness. This is complete madness. Perhaps there are perfectly innocent explanations for all of this. Maybe I just had too suspicious a mind. But I would like to know the truth. I want newspapers and investigators to be able to hunt down that truth and, where necessary, to publish it. So that's why I say to the Minister, we need action, and we need it now. We are still governed by that great European Magna Carta that we wrote in the 1950s, known as the European Convention on Human Rights. It establishes a positive obligation to safeguard the freedom of a pluralist media and to create a favourable environment for participation in public debate. We are failing to uphold that duty. This is not simply an abuse of libel law. Bill Browder was attacked using cross-border insolvency legislation. We've heard about how GDPR legislation is now being misused by oligarchs. Mr. Deputy Speaker, I was the Shadow Bill Minister on the GDPR bill. I can expressly tell the House it was not the intention of this Parliament, of the Parliament that passed that Act, for the Act to be used in this malicious way. So, the new anti-corruption strategy and the economic crime plan that the government has to refresh needs to include 5 quick provisions that would help. We need what are known as slap-back laws so that a judge can rapidly dismiss a case if it is designated a strategic legal action against public participants. Second, we need a public figure defence, like America has, which means that if you sue a public figure, you need a much higher bar to cross, and you need to be able to prove actual malice. Third, we need a sanctions regime against vexatious litigants that could include paying 100% of costs, or even punitive costs, in order to deter the kind of misuse of our courts that we are now seeing. Fourth, we need a defamation defence fund on the lines proposed by President Biden, and I would humbly suggest that it is funded by a windfall tax on the law firms making millions out of the misuse of our courts. Time and time again, in our research, we have heard about the behaviour of Hugh Tomlinson and Geraldine Proudler and Carter Ruck and Mishcon Derea and Shillings and CMS and Oldswang, and I have to say to the House, it is now time for the regulatory body to pass new rules to ensure that there is good model litigation principles and ensure rules of good conduct and indeed even liability on those firms for clients that refuse to pay their bills when they lose their cases, like Major Karpov. I give way to the honourable gentleman.
Yet another great speech. Is he concerned? Shouldn't these their bodies, these sort of solicitors' bodies, barristers' bodies, should be more concerned about the very, very questionable ethics and the behaviour of individual lawyers and individual law firms? They seem to be able to get away with whatever they want and offer whatever service, however questionable.
I think the honourable gentleman is absolutely right, and I think that when we welcomed the integrated review and the rhetoric of Global Britain, what none of us intended was that Global Britain meant that London becoming the capital of the global lawfare industry. Yet we know about the profits that are being made by some of these firms, who, as the right honourable gentleman eloquently said, are now carving out a pretty big, fat niche for themselves. Mr Deputy Speaker, I want to conclude with this. Once upon a time, Mr Churchill warned about an iron curtain descending across our continent from Stettin in the north to Trieste in the south. The challenge for our generation is very different. There is now a kleptosphere that is taking shape from Kaliningrad in the west to Kamchatka in the east. Every day, urgently, incessantly, patiently, friends of Mr Putin are trying to push the frontiers of that kleptosphere into the Ukraine, into the Balkans, into Cyprus, into Malta, into the Baltic, and yes, into Britain. It is pushed forward by attacking the weakest brick in our defences. And we in this House must ensure that our courts never become vectors for our country's opposition. For nearly 1,000 years, our courts have been sanctuaries of justice. Now they are becoming arenas of silence, places in which the truth is killed. It was Václav Havel who said that the greatest defence against totalitarians is to live in truth. Well, that is also the greatest defence against kleptocrats. Mr Deputy Speaker, I want to live in truth, and that's why I say to the Minister, it is now time for the government to act.
Just before I call Sir Robert Neal, just to remind everybody that the sub judice waiver is not a general waiver. It relates to specific cases, and if people wish to seek guidance, then clearly clerks at the table will be able to guide them properly so that they don't stray, which I know Sir Robert Neal will not do.
Thank you very much, Mr Deputy Speaker. I promise in my fairly brief remarks I will endeavour not to. I'm very grateful to my right honourable friend, and I congratulate him upon securing this important debate, because it is a very significant topic and one which has constitutional importance. I want to confine most of my remarks to the position of the legal system in the United Kingdom and bear in mind that just as living truth is a great defence against evil, so in practical terms, the greatest defence of our Constitution is the independence of the judiciary. And when we deal with abuse, we must, which undoubtedly occurs, and I'm grateful to my right honourable friend for highlighting some of the cases, and the one case I'll refer to is the appalling treatment of our friend and former colleague Charlotte Leslie, utterly disgraceful, and the worst type of intimidation of a thoroughly good person, as many of us would know, but there are many others. But when we deal with that, we have to be wary that we do not do so in such a way as we undermine the ability of the courts of this country to act utterly independently. And that will sometimes mean the right of an unattractive litigant to seek access to the courts. Indeed, that is absolutely fundamental too. So that's probably why it is right, and if action has to be taken, it's this House and Government must do it, because we cannot place the judiciary in the invidious position of having to make judgments as to the political acceptability or otherwise of those who might seek to bring claims before the courts, provided, of course, that there is at least a prima facie legal basis to bring the claim in the first place. And that's why I think the Right Honourable Gentleman Opposite's point about some of the measures that we might take to enable the courts to protect themselves are sensible. That's why the anti-SLAPP law is worthy of consideration, because that could, for example, involve an early strikeout mechanism that would speed up the means by which cases which clearly were brought without any substantive merit, were brought for purposes of intimidation through the war of attrition, which we find could be dealt with. And in that regard, it's useful to know that many lawyers and judges themselves have raised concerns about this. There was only at the end of last year a conference, a very useful conference actually, that considered this by the high-level panel of legal experts on media freedom. It's chaired by the noble Lord Newberger, the former president of the Supreme Court. Baroness Kennedy of the Shores, in any other place, is a member of it, and a number of others. They recommended that the Ministry of Justice move towards a consultation on anti-SLAPP laws, perhaps taking some of the best practice that is found in the States. We don't have to perhaps take all of the points that were suggested. I'd have some concerns about the practical impact of a defamation fund suggested by President Biden, but some of the other issues that are raised are well worthy of consideration. Of course, I happily give way to my...
I'm most grateful to my honourable friend. He is infinitely more expert in these matters than I am. But the point has been raised very clearly indeed on a couple of occasions already, that the regulatory bodies dealing with these law firms appear to be unwilling or unable to take any action. Can he suggest any way in which the law firms themselves can be brought to heel?
Let's be very clear. There are, of course, very significant regulations in relation to the conduct of law firms in the United Kingdom, and of course there are two separate regulatory regimes for the solicitors' profession, who of course handle client money and therefore have much greater checks in place to deal with money laundering, source of funds and so on very properly, and the position of the bar, who do not do that, and of course who act upon instructions which come via their professional client, the solicitors. And that distinction is important, and I'll digress just briefly to deal with that, because we do have to bear in mind that one of the key strengths of the British bar, both in England and Wales and in Scotland and Northern Ireland, the independent bar, is that barristers operate upon the cab rank rule. In other words, if you hold yourself out as having expertise in a particular field of law, and you're available to do the case at a proper fee that is offered for it, then you are professionally obliged to take it on, regardless of your opinion of the client. And that is utterly fundamental. Barristers do not and should not have the luxury of making moral choices about the people for whom they act. That's the essence of independent and objectivity at the bar. Of course I give way to my little friend.
You're saying that it is complete coincidence, and you may well be right, and I make no assertions, complete coincidence that Hugh Tomlinson keeps taking these cases.
If Mr Tomlinson practices in that field, it is open to him to take those cases. And I have to say that bluntly to my honourable friend, and it will be a very dangerous thing if Parliament ever sought to interfere with the rights of the client, of any lawyer, as to which clients they do or do not take on. that will be a very dangerous and slippery slope, and actually going in the sort of direction of the jurisdictions that we rightly criticise in this debate. I'll give way to my right honourable friend.
I'm sorry to press my honourable friend on this point. Is there also any requirement upon the law firm, the practice, the man, to establish the source of the funding that is being used to persecute people?
Absolutely. The regulations dealing with the solicitors' profession have very considerable requirements to track the source of funds, and that applies even at the basic level of doing a conveyancing transaction right the way up to being funded for the most complex litigation. So it is there. And I think we shouldn't mischaracterise the suggestion of saying that there is a high level of cynicism in the legal profession. There is not, and there is a failure of regulation. I don't believe that is the case either. I'll give way to my right honourable friend.
My honourable friend, who's, as has already been said, is infinitely more expert in these things than most of us. May I just bring him back to this question, Mr. Hugh Tomlinson and other firms, and say to him the answer to this may be looking very closely at the tactics that have been put together by these firms, which then give them that niche, that commercial niche. I was talking about very profitable commercial niche. If we judge that those tactics are unfair and unjust, that would solve the problem of individual firms or individuals appearing in more and more of these oppressive cases.
Well, let's put it this way. If this House, if Parliament decides as a matter of policy that certain behaviours are undesirable and should be constrained by law, that is for this House to do. And the courts would then faithfully apply that law that Parliament has passed. And that would be the right way, my judgment, to deal with it, in fact. And that includes the law which regulates any of the professions. So I think, for the reasons I said, we should be very wary indeed about fettering the ability of lawyers to defend unpopular clients. That's not the same as unmeritorious clients, but just remember why. There are many instances where actually injustice has been prevented by lawyers taking on an unpopular client and an unpopular cause. So that's the bit that we have to put into the balance on the other side, lest we entirely move down the way of saying that because we disapprove of someone, we should deny them redress to law. Yeah, of course I would.
The right honourable gentleman is doing an immense service to the House this afternoon in the way that he is bringing his expertise to this debate, and I agree with him that we need to be circumspect and actually empower judges to deal with abusive courts. Judges know an abusive court when they see one. But in Major Karpov's case, here was a man that was being paid £15,000 to £20,000 a year in Russia, but he was somehow affording lawyers that cost £600 an hour. So there must be some kind of weakness that we need to fix if lawyers genuinely are to understand the source of the money that is ultimately paying their bills.
Obviously, I'm not in a position to consider the individual facts. If people have suggestions and specific examples where it might be suggested that there has been some failure in the regulatory environment, then of course they should bring that to the attention of the regulatory authorities. My experience has been that they do take their job very seriously, and I know the Ministry is very aware of that. But if there are specific examples, of course, one should never be afraid to look at those and see if anything can always be improved. I'm very open to that. What I wouldn't want to do is to throw out the baby with the bathwater in the way in which we approach it, and that's why I'm arguing for this balanced approach. I'll give way to my honourable friend. I will try and make a bit of progress because I've given way quite a number of times.
I think he's making fantastically important points, and I think we're testing on him because out of respect for his background and experience. And the idea that the lawyers, as much as we like or dislike individual cases or individual laws, should be independent, absolutely we all agree with. But we are talking about systemic failure here that allows this corrupting industry to grow. And on the point that my honourable friend was just making now, Bill Browder has directly alleged that CMS was taking instruction from Russian organised crime by middlemen, and they don't seem to have been doing very much about it or seem to be hugely interested where that money was coming from.
So we must always make sure that the regulatory regime is kept up to date and fit for purpose. And that applies actually to a number of the tools that we have in dealing with this type of corruption. That also applies, for example, to the resourcing of the Serious Fraud Office that's been mentioned in the course of this debate, to make sure that they have both the technology and the manpower to deal with these complex investigations, making sure too that the courts have the technology sometimes to deal with complicated matters as well, and certainly the regulatory bodies, and there's no problem with that at all. I think the key bit that we must do is preserve the independence of the regulatory bodies, and that's best done by us setting a proper legal framework, which is our responsibility, and then giving them the tools to do their job on a day-to-day basis in an independent fashion. I don't think there's actually any dispute that I can see around the Chamber in relation to that. I think it's important too that we do look at practical measures, and as I say, the possibility of the Ministry, and I hope they will consider this, consulting on anti-SLAPP laws in broadly the form of the United States, say something which distinguished jurists like Lord Neuberger think is well worth considering, would be a sensible and constructive step forward. The high-level panel also suggested some reform to the civil procedure rules. That could be fairly readily undertaken, and that's something which we could ask the judiciary themselves to look at, because they must themselves be master of their own rules rather than us dictating there. But, for example, it has been suggested that amendment to Civil Procedure Rule 24.4 on summary judgment could be adjusted to make it easier to deal with such with such unmeritorious claims where they are being pursued for abusive reasons. For example, deliberately stretching out proceedings to run up the costs. Perhaps greater use of security for costs could also be undertaken. Now, those are practical things which I've no doubt the courts would be willing to do, and that we could ask them to consider. The broader legislative framework of the anti-SLAPP law, as I say before, is down to this House, and I, for one, will be very open to looking constructively at that. So that's the balance that I wanted to get into the equation. And how do we make sure that the reputation that we have in this country as being a jurisdiction of choice for litigation, quite exceptional benefit. The Justice Committee members and I met with the Justices of the Supreme Court just across Parliament Square only yesterday, because we thought it would be useful to start more of a dialogue between the legislature and the Supreme Court on matters of importance. We have there men and women of the very highest integrity and intellectual ability. But they were reminding us the very high percentage of cases which they deal with, even at the final appellate level, which are involving international parties. That of itself isn't a bad thing, and we shouldn't allow anybody to think that that's ever a bad thing. It's because generally bona fide commercial organisations or individuals choose to litigate under English law precisely because it's trusted more than anywhere else, precisely because of the independence and because of the rigour. So how do we preserve that and at the same time update where necessary the tools to prevent abuse of that system? And that's the trick, if you like, that we've got to pull off, and I'm sure with goodwill that can be done. The final thing I was going to say, Madam Deputy Speaker, in this context was, again, it was referred to by other speakers in the debate, is the importance of our continued engagement on an international sphere on this. And I, for one, would particularly stress the absolute importance of our continuing within our obligations to the Council of Europe and the Convention upon Human Rights. That's something that I regard as absolute red letter in terms of our constitutional and legal position, and a massive benefit to the UK. I had the honour to serve on the Parliamentary Assembly of the Council of Europe for a number of years before I became chairman of the Justice Committee, and in that role I represented the Parliamentary Assembly on what is called GRECO, the group of member states against corruption, in which the Ministry of Justice has officials who regularly sit on a permanent basis as well. And the admirable work that he's done there, including, interestingly, by some of the emerging democracies in Eastern and Central Europe who recognise the need to clean up their own systems and reputations, is really important. Of course, I'll happily give way.
The Honourable Gentleman is being incredibly generous. I just wanted to underline that the Ministry for Justice is obviously out for consultation on reform of the Human Rights Act, which helps enshrine ECHR. Does he agree with me that it is absolutely essential that there is no backsliding on our obligations to preserve a pluralist media environment with a vigorous public debate and cherish of free speech?
The protection of the media and right to free speech is fundamental to our convention obligations, and we certainly must never do anything that reserves for those. There's a separate debate about what are the mechanisms with which we in our domestic courts enforce the convention obligations, but our commitment to the convention itself must be absolutely crystal clear. And so, too, I believe, must be our commitment to the institutions which have been put in place to actually assist on a cooperative basis with those matters. I've referred to Greco, which does excellent work, and of course also we shall mention, particularly in the terms of dirty money, which is undoubtedly a real problem, no question of that, to Moneyval. That's the committee of experts on the evaluation of anti-money laundering measures and the financing of terrorism. They're not the catchiest of acronyms, but they do actually very valuable work. And perhaps, too, finally, we could look at what we do around the issue of cross-border insolvency. That's not one that is an easy fix because, again, the cross-border insolvency regime stems from a number of international agreements that we have entered into, which in many respects bring considerable value, commercial value to British companies and individuals. But again, there's no harm in looking at that if that is an issue where there is some potential abuse. The final thing is perhaps, and it's right to say, and again it's been referred to in discussions that I have had with practitioners and judges, and as well as the cross-border insolvency being an issue that we need to protect from abuse. We also need to look at potential loopholes in the data protection legislation. Again, that's for us to do because we as a House pass that legislation if time has shown that there are areas of defect that need to be addressed, and absolutely right, we shall move to address that. Because then, again, if we address that, I have absolute confidence that judiciary will enforce that policy decision that we take in this place under our constitutional rule, and they will play their constitutional part to enforce it. So this is an immensely important debate, and I'm very grateful, again, to my right honourable friend for having raised it, because our international reputation is critical, the reputation of our judiciary is critical, and I get the sense that nobody is for 1 second calling that into doubt. But we do have to find a sensible and balanced and proportionate means of making sure that whilst we uphold that and its fundamental independence, we do so in a way which prevents abuse. And I think that's an objective that we certainly warrants further debate and consideration. I hope the Minister will take that on board as we go forward.
Beg your pardon. Afsana Begum.
Thank you, Madam Deputy Speaker. I want to thank the right honourable members for Halterman Howden and Birmingham Hodge Hill for securing this important debate. Litigations against public participation are abusive lawsuits, I believe, that are pursued with the purpose of shutting down acts of public participation. And as the right honourable member for Halton, Price and Howden mentioned, they can come in many guises, covering many different areas of the law. The House will be aware that I was completely cleared and vindicated in Snaresbrook Crown Court last year after what I and many in my constituency and around the UK view to have been vexatious litigation pursued with the purpose of shutting down my public participation as a democratically elected socialist member of Parliament and as a survivor of domestic abuse. To put it very simply, I do not believe that I would have had to endure such an ordeal if I had not stood up against domestic abuse, harassment and intimidation, and if I had not had the audacity to put myself forward as a socialist to represent the area where I have lived all my life. The use of courts to try to pull down political opponents is fundamentally undemocratic and against the public good. Firstly, my case raised questions about the independence of local bureaucrats and whether they can be trusted to deal with imprisonable offences, because of course the legal action pursued against me was not taken by the Crown Prosecution Service, but brought by my local council spending over £90,000 of public taxpayers' money. Nobody, absolutely nobody involved in pursuing this trial seems to have found it remotely odd that the complaint was made by my ex-husband's brother-in-law, submitted after my being selected as the left candidate to be Labour's parliamentary candidate, and coinciding with the day when the nomination papers had to be formally submitted. or that the people who were opposed to me being selected as the candidate, including my ex-husband himself, being in positions of political oversight. Surely, given such conflicts of interest, at the very least, the case should have been referred to the CPS. Secondly, my case demonstrated problems with the way the legal system deals with domestic abuse and indeed the increasing prevalence of cases like mine where I firmly believe that the legal action taken against me was an extension of this abuse and the ongoing intimidation and harassment subsequent to my escaping a very bad situation which continues. I found it bizarre that such a spurious case could be pursued against me when I had been told that too much time had been passed regarding the abuse I had suffered, despite the period in question being the same. Indeed, the local authority were made aware of the abuse from day one, and indeed this was never challenged by the prosecution during the trial. A list of agreed facts was read out at the trial, including medical records and police records. Perversely, the domestic abuse was so accepted that in cross-examination it was used against me in order to suggest a motive for the alleged crimes. My ex-husband, also a sitting counsellor, was very tellingly not called to give evidence by the prosecution themselves. All throughout the message came across again and again the message that my being a survivor of domestic abuse had no bearing on how this investigation was being conducted. But how can this be? How many other women is this happening to? I had to be aggressively cross-examined and humiliated in front of the world, with political opponents and my ex-husband's brother-in-law sitting in the public gallery about issues of such personal pain and trauma, because this case felt as though it was about destroying me, and at times it very nearly did. The complaint was leaked to the media even before I was made aware of it, and there appeared to be a regular source of information flowing to keep the media updated. And I want to be clear, when I won my selection, I was a divorced 29-year-old of modest means. I did not own anything, not even a car, and I'd been struggling for years to rebuild my life. And suddenly, I had a target on my back for the far right to throw all their bile and hatred at. But the media did not let truth and decency get in the way of a good story and the opportunity to bring down a socialist feminist Muslim woman who would go on to become the first hijab-wearing MP in this House. Why is it the case that almost anything is allowed to be written and said about me, fueling Islamophobic abuse and death threats over social media and leading to the judge in my case to issue warnings for my protection? As such, I want to make a really important point here about the legal system and access to it, because I grew up in the reality of the world out there. I did not know at the time, didn't have the means or the connections to be able to pursue cases against various outlets. Defamation is an area of the law that is very rarely the terrain accessible to working class people. And I think that's very important for the purposes of this debate, for us to really have this in mind. And equally, whilst I do agree that media freedom is paramount, I think that media accountability is still something that needs to be addressed more fundamentally. I'm not interested in defending elites from justified criticism or preventing the public from scrutinising those who represent them, including myself. But what I am interested in is defending the fundamental structures of political freedom and democracy. And in this sense, the media are also in positions of power and leadership in public life, and as such should have a regard to consider how their tone is likely to shape public debate. Yet in my case, the so-called scrutiny was not even well-researched, well-written or accurate. It was derogatory and dehumanising. And I always wonder if the outlets publishing this stuff ever thought about what they were doing to my life, the risk that their actions were placing me under, or what my case meant for survivors of domestic abuse and Muslims across the country. Do they ever consider what their intimidation based on prejudice or hate, which has disproportionately negatively impacted on women, ethnic minorities, the LGBT community and other candidates from minority groups, does to people's mental health and well-being? Clearly, my ex-husband and my political opponents thought I would just submit and be intimidated into going away and hiding. But it is via the solidarity of local people and Labour Party members, including my honourable friend, the member for Streatham in particular, that I knew that I could not let this happen to me, and I found the strength again to survive. Not least because I felt a duty to socialists and women everywhere to defend myself and pursue justice. Yet, on being vindicated, people might think that this is the end of it, but the smears do continue and my reputation has been damaged. But more importantly, the claims of defamation and libel were now being fired at me and people supporting me. I couldn't believe it at first, and it seemed so ludicrous. I remember how heartbroken I was when I was finally able to tell my story after the trial. The media felt it necessary to print a disclaimer from my ex-husband uncritically. I felt that they were highlighting this as his warning to me. I'll give way.
Lady for giving way. She's making a very powerful speech, and I wasn't aware of all the details of what she's been through, and obviously I don't share her politics, but could I commend her for speaking about domestic abuse in this House, as my honourable friend and personal friend, the member for Burton, did recently as well. The more women that do that in this place and share their stories, the better it is for women across the country.
Member for his strong point, and I followed the case very closely about his colleague that he mentions, who is incredibly brave to come forward as well. This is not unique to my experience, and we know that powerful men use their power and law to silence women. Now, according to Southall Black Sisters, they almost had to withdraw into 2017 from a documentary on domestic violence because of the insistence that the husbands of the unnamed women alleging abuse and abandonment be given the right to reply in ways that negated the women's accounts of abuse and exposed them to risk of reprisals. And we know of the series of libel cases where wealthy men have sought to protect their reputations from women who accuse them of abuse. Now, I note under the Defamation Act 2013, the defendant in libel cases can argue a public interest defence, but this is not available to survivors. Yet, I never wanted any of this. I was forced into a situation where I had to speak out, and now I do feel an obligation to continue to do so because, Madam Deputy Speaker, this must never happen again. What has happened to me, what does that say to survivors of domestic abuse when we know how difficult it is to come forward? To conclude, Madam Deputy Speaker, I believe in democracy, and that this means that people from all walks of life and backgrounds can put themselves forward to be considered in democratic processes. This is a question of public good. The increasing prevalence of intimidation of parliamentary candidates and others in public life should concern everyone who cares about our democracy. This is a question of public good. And it's important to be clear, I think. Lobbying, campaigning, disagreeing and opposing representatives is not what I'm talking about here. Actually, the opposite. Intimidation is about seeking to use undemocratic and underhand means, often using establishment power to literally destroy someone's life. And finally, I believe no one should suffer domestic abuse, and anyone in such a situation should be supported in speaking out. This is a question of public good. Thank you.
Sir Roger Gale.
Thank you, Madam Speaker. I shall be very brief indeed, because so many of the points that I had intended to make were made eloquently by my right honourable friend, the member for Halton Price, and indeed the right honourable gentleman, the member for Hodge Hill. Madam Deputy Speaker, we've come a long way, I think, since Robert Maxwell, the late Robert Maxwell, sought to persecute Private Eye through his bank account. What we're dealing now with is a wholly different scale of abuse. And it's saddening to hear the extent to which London has now become perhaps the money laundering capital of the world. We know, because we do know, that there is investment in football clubs, in property, in businesses that is bought by dirty money. And we have a very fair idea of where that dirty money has come from. And it isn't only the Russian Federation. It is Azerbaijan, it is countries in the Middle East, it is other countries of the former Soviet Union. But it is the oligarchy. It is the kleptosphere, as the Right Honourable Gentleman said earlier. I am in no doubt, having spent, as others in the Chamber have, some time with the Parliamentary Assembly of the Council of Europe, of the extent of this influence, but more importantly than that, of the link, the direct link, between those carrying the money bags and Putin's Kremlin. And that is unacceptable in a civilized society. And the fact that there are law firms in London who are aiding and abetting those who are seeking to use the law to suppress the voice of truth is an absolute disgrace. And that is why I asked my honourable friend to what extent the legal profession takes trouble to try to identify the source of the money that they're being paid with. And I cannot help but feel that the regulatory bodies, the solicitors' profession and the bar, need to ask some rather more searching questions. The Convention on Human Rights is founded upon the principles of free speech, of a free press in free democracy. And if we allow our country to be used as a base to suppress that free speech, then we are on a very slippery path indeed. So all I want to say to the front bench is the case has been made. The Minister has heard the case. We cannot any longer allow this to go on. We have to take action to ensure that anti-SLAPP laws are introduced, that proper controls are exercised to prevent the abuse of our courts, and to try to protect those who seek to investigate and then to publish the truth. Thank you.
Clive Efford.
Thank you, Madam Deputy Speaker. I congratulate the Right Honourable Member for Helton Price and Howden and my honourable friend, Right Honourable friend, the Member for Birmingham Hodge Hill, on securing this debate. I chose to speak in this debate because, like many others, I've got growing concern about the use of slaps to silence those who try to shine a light on wrongdoing. There's a growing problem, as my right honourable friend has said, of global kleptocracy. Those with enormous wealth, who may have gained that wealth through dubious means, who seek to manipulate our legal system in order to avoid scrutiny of how they assess their wealth and how they use it. Our legal system is protected throughout the world, and we are respected for fairness and justice in this country. And it is designed to defend our rights, to protect ordinary citizens from being adversely affected by those who break the law or would seek to take their rights away. It defends our need for freedom of speech, a free, independent press. In the UK, we pride ourselves on the sophistication of our democratic system, our legal systems, and our free press. So when we see one part of that system being used to diminish another part, essential part of it, in the form of a free and independent press, we undermine ourselves and the status of our own country. And it's important in a democracy like ours that we are able to speak truth to power. and that we know what is being said and what is being done, so that we can form our own opinions. But the increasing use of strategic litigation against public participation, SLAPs, is undermining that important part of our democracy. And it's concerning that we are seeing one pillar of our democracy, in the form of the legal system, being used to silence those who would expose wrongdoing. There are too many disturbing examples of investigative journalists, for example, being silenced by those who are immensely wealthy and have issues about which way they want to be held publicly accountable. This is done. They silence these individuals through abusive legal lawsuits that threaten huge damages, that constantly require responses for disclosures, which in turn saps up the resources of those organisations or individuals that are subject to these abusive lawsuits. It's not only journalists, whistleblowers, activists, academics, NGOs, but more disturbingly, in my opinion, is even our regulatory bodies are not exempt from this. And it's not just the bodies themselves, but they target individuals within those regulatory bodies in order to silence them. If those organisations and those bodies that are set up by legislation that we pass through this House, through our democratic processes, are allowed to be undermined by the imposition of these slaps on individuals who are carrying out their duty in those organisations, then our democracy itself is undermined. And the point has to be, and I know that the Right Honourable Member for Helton Price and Howden went into this in detail, but this case of the Eurasian Natural Resources Corporation, ENRC, which raised legal action against individuals, not just the Serious Fraud Office that was investigating the activities of ENRC, but individuals who worked for the Serious Fraud Office. And if those individuals are going to feel that they're exposing themselves to this type of action by carrying out their duty, then they're bound to think twice about whether they should do so. And as the Right Honourable Member earlier said, that this investigation has gone on since 2013. It's not even reached the courts, but ENRC have issued several of these slaps in order to silence and stop that investigation. We can't allow this to go on. And it does seem to me, and the Right Honourable Member for Bromley and Chislehurst, my neighbour, who I have an enormous amount of respect for and did listen closely to his speech. Despite what he has said, there are a significant number of firms within the law profession that turn up and defend these organisations and individuals that are using these slaps. And I fully understand the taxi ranking system. I've operated it for many years, and I've also understand the concept of brooming, which people here may not, but I bet you've all experienced it. And that's the sound of a vehicle, the accelerating being pressed when somebody doesn't want the job and they broom off. So brooming, I'm sure, exists within the legal profession because there seems to be a number of individuals that turn up in actions in these legal lawsuits. And that can't be coincidental. So there's clearly something within the legal profession that needs to be examined. We have to accept that there is a problem here. And I would put it into basically two areas that need to be examined. One is we have to accept that London is becoming a centre for laundering dirty money. Now, the Prime Minister has claimed, through one of his spokespeople, that London has some of the strongest control systems in the world. But this doesn't explain the criticism of the regulatory regime. And I'm quoting the Financial Times. Becoming a money laundering centre is an inevitable risk of being a global financial centre. But UK authorities have for far too long been reluctant to adopt and enforce tougher safeguards against dirty money for fear of harming Britain's image as an easy place to do business. Well, I would say that becoming the international centre for dirty money is far more damaging for Britain's image as a place to do business than is the exposing of these activities that are currently taking place. And more harm will come to Britain as a consequence of doing nothing or delaying action. And what does it say of global post-Brexit global Britain? Surely part of making Brexit work has to be setting the highest standards here in Britain, for which, after all, that is the reputation that we have had over many generations, and we should defend it even more so vigorously at this time when we are now global Britain on our own after Brexit. So we have to act. Now, I don't want to demand that slaps are introduced that might end up defending huge media corporations that took away or abused the freedoms of individuals through the hacking scandal. To create a system that would create a loophole for those organisations, that would be a huge mistake. But neither do we want to enable our legal and financial systems to be abused by criminals who want to buy influence through political donations and silence those who would expose their illegal activities through the use of these abusive legal actions. So we need to, the government need to review this issue around slaps and think about regulating in that area without delay. We should also be taking action to protect individuals who work for agencies that should be investigating these individuals, and particularly protecting individuals who work for those agencies who may be threatened with legal action. But the most important thing of all, I think, is the reason why I wanted to contribute in this debate today, is to demonstrate to the government that there is a growing concern about the use of slaps and the abuse of this by extremely wealthy and powerful people who maybe obtain that wealth by dubious means. That voice is growing, and the time for action is now.
Yeah.
Bob Seeley.
Indeed, Madam Deputy Speaker, and I thank the Honourable Member for Eltham for his speech, and I agree with many of the points, and I think we will. Normally, when people agree on stuff in the House, it's normally maybe because there's a bit of virtue signalling going on, but I think in this case, agreement actually shows serious concern about a really serious issue. And I thank both the member for Birmingham Hodge Hill and my honourable friend for Holton Price and Howden for bringing this debate. It is one of the most important debates that I think many of us would have spoken in our time in the House. The abuse of UK courts by organised crime, by oligarchs, by authoritarian states and their wretched proxies is, I believe, a significant threat to the corruption of the UK legal system, to freedom of speech, and especially, as the Honourable Member for Eltham was saying, to the conduct of due diligence against potentially corrupt actors who would threaten the health of our institutions. I agree wholeheartedly with what our Honourable friend, the Member for Bromley and Chislehurst, was saying, that nobody here is questioning the independence of UK courts. Nobody here is saying that we don't want to continue that independence. And it is also true to say that London is a very important financial and legal centre, and long may that continue, because it brings in a great deal of money and wealth and employment into London and into the UK. But I hope what the Minister will understand is that bad money drives out good, and bad law will drive out good as well. And if we allow this cancer of the selling of intimidation services by high-end legal firms, it will not do us any good in the long run, in the same way that letting mafias launder money would be bad for us in the long run. So let me be clear. Whilst these tactics are sold by law firms to many different actors, organised crime, corrupt corporations, I think they're very much part, as some of the members have said, of the Russian state playbook and of Russian hybrid war tactics, the tools of non-military conflict in the West against the West. I will argue, Madam Deputy Speaker, for significant reform of this corrupting cottage industry, which enriches the few at the expense of the whole. We do need to bring in SLAPP legislation, anti-SLAPP legislation, and we need to go after those lawyers, dare I call them slappers, who would use this. We need anti-slapper legislation. We also need, I believe, a much more robust public actor defence. They have this in the United States, and I believe we have to bring it in here as well. And finally, I will make the case that we need a foreign lobbying law, Foreign Agent Registration Act, some people call it, so that those law firms that sell these services, reputation management, and the related industries such as commercial spying and dirt digging on people, have to be clear about their business models, and when they sell this to overseas entities, be it major and questionable corporations, be it Mr. Putin's proxies, they need to give us that information and put that information in the public domain so that the foreign lobbying law will help us identify who works for foreign actors and what they are doing. We've discussed the various definitions of lawfare, so I won't go into that, but there appear to be two important elements to it specifically that I'd like to address. Firstly, it is when, as we've seen, the law is used to intimidate, to wear down, to financially destroy journalists and campaigners. And second, as the Honourable Member for Eltham has just said, where the law is used to intimidate organisations into failing to conduct due diligence, which is a massive potential issue if we allow bad actors into our energy markets, into our food markets, into our telecommunications markets. I lived in the Soviet Union back in 1990 to 94. I lived in the Soviet Union and post-Soviet states, and I have made an academic... in my academic work, I have studied as hard as I can types of Russian hybrid war. And just a little bit about the background to this. In Russia, the ultimate outcome for a journalist who crosses the rich and powerful and can't be silenced is death. They're murdered, and nearly 24 have been murdered under Mr. Putin's leadership in the country. In this country, the murder of Western officials, UK officials, UK journalists, is not yet part of the oligarch or organised crime playbook, although it is in other EU countries. So it is a danger. So other methods are used. And two of these methods that we've heard today is the use of libel law and the use of data protection law to intimidate and destroy financially. So reporters, campaigners and activists in our state are not threatened with physical destruction, but they are threatened with financial destruction. It is the sort of compromat corruption industry from Moscow and St. Petersburg which has sadly been exported to our country. Publishers as well as journalists are intimidated into silence, and I congratulate massively HarperCollins for fighting these cases. If every time HarperCollins has to pay out $5 million or $2 million in court costs, the message is clear. Don't write about Russia. Don't write about those close to the Russian leader. Don't write about those state oligarchs who hide their dodgy dealings in plain sight. And the result for the UK and for the wider world is that freedom of speech, as many of us have said, is being stifled. Journalistic investigations remain unlaunched.
I thank the Honourable Member for giving way. Does he agree with me that if the government is going to tackle the examples he's been giving in terms of Russian interference, that we must also contend equally with actions and activities by the US government? And does he appreciate that the case of Julian Assange is relevant in this matter, where it has been reported that the US had plans to assassinate him in British soil, and he languishes in prison at this point?
I'm not quite sure the case that the Honourable Lady is talking about, but the principle is clear that SLAPP legislation doesn't just apply to one country, to one industry, to one person. SLAPP legislation is there to prevent lawsuits, to prevent public participation. It is in favour of good journalism, good campaigning, good activism. It would not support, as the Honourable Member for Eltham said, rich companies hiding their hacking activities. That would not be purposeful. But it would support bad actors trying to prevent information and important information coming out. We've had several high-profile examples in recent years which expose slightly different tactics in each of the cases. Catherine Belton and HarperCollins, Tom Burgess, Chris Steele, Bill Browder, and the former Member of Parliament, Charlotte Leslie. And I thank them all for fighting their battles. Those firms who offer and sell, dare I say it, legal intimidation services to the corrupt, to organised crime, to Russian state proxies, or to the Russian state or its proxies, allegedly, so we are told, include some of the many names that have been mentioned thus far: CMS, Mishcon de Rea, Scadding, Carter Ruck, allegedly Shillings, and Harbottle and Lewis, who service Mr Abramovich's needs. So what do these tactics look like? Well, against Charlotte Leslie, the Carter Ruck strategy appears to be to ratchet up exorbitant costs in the hope of achieving a technical victory on data law, and then inflicting those costs on Charlotte and her team in the hope of bankrupting her and her organisation. So in 1 week alone last summer, she received 12 letters. Carter Ruck then threatened other of her directors, despite the fact that they have not taken part in any way in any of this activity. Catherine Belton and HarperCollins, as we've heard, were hit by multiple suits from oligarchs close to President Putin. In Bill Browder's well-known case, very modestly, as the Honourable Member for Hodghill mentioned, a relatively lowly official in the Interior Ministry in Russia, who was allegedly part of a campaign to steal tens of millions of dollars. He was linked to the murder of Sergei Magnitsky, hired, I think Olswang CMS as they're now called, to go after Bill Browder via a bogus bankruptcy claim. The lawyer in question, Geraldine Proudler, used to, if the internet is correct, sit on the Scott Trust, which oversaw The Guardian, and apparently now sits on the Guardian Foundation Board. And I'm going to come back to that, because I have questions for the editor of The Guardian, but I do not support any side that takes questionable funding, whether they are political parties, mine or others, or lawyers. And this is not about score settling, and I'm very glad that they have pointed out where we are not living up to those standards, if indeed that's the case. Against Tom Burgess, we've heard of the Kazakh mining company ENRC initiating 18 legal proceedings in the UK and the US against lawyers, investigators, and seriously, the Serious Fraud Office. Journalist Dan McCrum, when he was being investigated and chased, all those people came out of London. Potentially the most important as well, in some ways, is Daphne Galizia, the murdered Maltese journalist, who was facing 47 lawsuits at the time of her murder. According to her sons, Mishcon de Rea, quotes, sought to cripple her financially with libel action in UK courts. They also said the campaign for justice in our mother's case cannot be disentangled from the abuse that she suffered at the hands of Mishcon de Rea's lawyer. The firm sought to cripple her financially with libel action in the UK courts on the instruction of Henley and Partners. Had our mother not been murdered, they would have succeeded. They then added that the firm has constantly threatened and harassed not just our mother, but countless other journalists worldwide. And effectively, she was about to be financially destroyed before she was, by others, physically destroyed. But the principle was the same, that she was to be silenced at all costs. I have to say, look, you look at all these big fancy posh firms that charge apparently double, triple rates for doing this sort of work, and you look at their websites and you think that butter wouldn't melt in their mouths, and I'm sure they do pro bono work. But this sort of work, offering these sorts of services to some of the most unsavoury human beings and organisations on the planet, is deeply immoral, and I believe it is deeply corrupting to those otherwise upstanding firms who should be doing more to protect and not corrupt our legal system. What is being offered here in this cottage industry that we are talking about of lawfare is the legalised intimidation of some of the most deeply unpleasant individuals and organisations on the planet. And these companies are going out there trawling for business because it is so well paid. And I believe those lawyers, to put it bluntly, who do this work should be deeply ashamed of what they do, because they destroy the integrity of the UK legal system, not uphold it. They can, as I say, charge double or triple, but this is a moral abuse of the law, and they know it. What else I want to say? One specific point about Geraldine Proudler. Again, I look at her reputation and lovely website and all that. Bill Browder told me CMS takes effective instruction via middlemen from Russian organised crime and for individuals who have since been sanctioned under Magnitsky. My question to Catherine Viner, who is the editor of The Guardian, is what on earth is Geraldine Proudler doing on the Guardian Foundation if she's still a member? What on earth was somebody who was defending a sanctioned Magnitsky entity person who was engaged in that case? What on earth was that person doing on the Scott Trust? What on earth has the Labour Party said about that? Again, I do not defend one side or the other, but there are folks in this House, on that side of the House, who you should be saying to The Guardian, what on earth are you doing? And I'm sure there are other examples that can be thrown our way, and I'm not going to defend anyone here. The Board of English Pen, which campaigns to defend writers and freedom of speech, decided in 2018 to retain the libel lawyer Anthony Julius as a trustee. Mr. Julius, I'm sure, is a fine and outstanding man. He was also a senior at Mishcon de Reya, the firm that hounded Daphne Galizia to her financial destruction prior to her physical destruction. I find this unspeakable that these people have got away with this behaviour with absolutely no reputational damage to them at all. And yet they are doing things which are actively bad for freedom of speech, actively bad for any concept of truth, actively bad to the UK legal system in this country. I won't go on for too much longer, just a couple of other points if I may. There is a second element here which is critical, and that is the intimidation using data protection laws of those people who are doing due diligence work on our behalf as civil servants. We've seen the ENRC, as part of its waves of lawsuits, has started proceedings against a serious fraud officer or was threatening to do so. I understand that threats of judicial review have also been made in relation to the decisions made by Bayes and the Special Immigration Appeals Commission. We are getting into very serious territory where the functioning of government, as well as the exposing of truth, and dare I say it, stuff, concepts like justice, is being severely hammered and severely damaged. But then we move on to another aspect, which is not only the financial destruction facing journalists, but also the reputational destruction. I understand that in the case of the Carter Ruck versus Charlotte Leslie case, PR agencies were working hand in glove with the law firm, Phil Hall Associates, Kroll, K2 Integrity, a company that helps with litigation support and reputational defence, aka dirt digging on other people. I think we are importing too much of the Russian tradition, and there's a specific Russian tradition of kompromat, the collection of compromising material, which started under the Soviets and is now a huge industry there, kompromateriushi material it's called. And that is the collection of material which is then found is used to blackmail or destroy individuals. And in this country, it happens at the same time of racking up extraordinarily large legal bills. So I believe this cottage industry of corrupt activities is actually pretty vile. I think it undermines the legal system in this country, not supports it. And it undermines freedom of speech, not supports it. So what needs to be done? The government apparently wants to reboot. I congratulate it on that. I think it needs to. May I humbly suggest that one of the ways that we could be supporting higher standards in public life is by gripping this issue. Libel tourism should effectively be outlawed. First point. Second point, let's look at bringing in a robust public act of defence which raises the bar at the rich and powerful taking on campaigners and journalists. Thirdly, let's have statutory regulation of private investigators and firms that take on the collection of compromat. Let's bring in slap legislation fourth and fifth. And again I say this, we need a foreign lobbying act as part of the updating of our lobbying laws in this country, which are not fit for purpose, and explain why the UK remains an influence peddler's paradise. I have been urging this for 4 years. I produced a study of options for government about 18 months ago. Corruption scandals, sleaze scandals, lobbying scandals will continue ad infinitum in this country until we grip this issue and we do something about it. So summing up, I do not want to get in the way of client confidentiality, but I want to know what these firms are doing working for these oligarchs. I want to know how many hours they're billing. I wouldn't mind knowing what rate as well, to be honest. I want to know what they're doing, which bits of those companies are doing what, and why. We need this in the public domain for the good of us. We need this cottage industry, if not shut down, then severely limited. And I will continue to fight for this, as I know others will, because it is very important to the law system and the legal system in this country. Because although it's a highly paid industry, it's a corrupting one. It does not seek to strengthen freedom, but destroy it. It does not seek to defend justice, but to undermine it. It is a growth industry, but in the same way that cancer can be inside a body politic, and it needs to be cut out. And I believe that those who work on behalf of foreign states and proxies and organisations betray our values and the values of our legal system and our nation. Thank you.
Aaron Bell.
Thank you, Madam Deputy Speaker. It's a pleasure to follow the Honourable Member for Isle of Wight, and a pleasure to contribute to this excellent debate secured by my right honourable friend from Halton, Price and Howden. I'm very grateful to him for securing it. I'm also very grateful for the briefing he arranged for members earlier this week to explore some of the issues behind this. I do want to touch on the really big issues that we've already talked about. I also want to briefly mention a local, low-level lawfare issue in my constituency, that of Wally's Quarry Landfill, which I've referred to many times in this House, which is a landfill run by Wally's Quarry Limited, owned by Red Industries, which is controlled by Mr Adam Sher, a convicted criminal who went to jail over bugging the Environment Agency over another landfill in the 2000s, another landfill which had remarkable similarities to Wally's Quarry, with the odour overcoming many residents in the local area. Residents were bugged, the Environment Agency was bugged, the local councils were bugged. And that company is very litigious, Wally's Quarry Limited. They have tried to sue me. They have sent legal letters to my council leader, Simon Tagg, County Councillor Derek Huckfield. They tried to secure an injunction against protesters at the last minute the other day, only to be defeated by a woman on Zoom at the High Court on her own, Audrey Young, with no legal representation, defeated that injunction. I pay tribute to my constituent for that today. It's a slightly lower level case, and I won't go into any further detail for the House today, but I do hope that the journalists who want to publish what they know about what's been going on at Wally's Quarry are able to convince their lawyers to stand up to the lawyers that are employed by Wally's Quarry Limited. Now, we've heard today about how our libel laws are being used to silence journalists, how the Data Protection Act and GDPR is being used to harass investigators, the abuse of subject access requests, trying to obtain special personal data, and when that fails, as the Honourable Member for Aberavon, who's no longer in his place, said in his intervention, there's the hack and leak approach, where they hack into it, they publish the data, and then they sue them for having had that data in the first place, which is surely absolutely ludicrous. And we also hear about how judicial review is used to threaten our government agencies and our regulators, like the Serious Fraud Office, for example. The Bureau for Investigative Journalism described that the city law firms acting on behalf of those under investigation are, quotes, completely outgunning the SFO in terms of litigation tactics and resources, and they raise concerns that, quotes, an imbalance of arms is allowing some oligarchs and some powerful corporations to, quote, buy impunity. That's what's happening to our regulators right now in our own courts. It's ludicrous that this is permitted. What do we need? I'm not going to speak for long, Madam Deputy Speaker. What do we need? I think, first of all, the Right Honourable Member for Bromley and Chislehurst described the independence of the judiciary as one of our essential bulwarks, but another, freedom of speech and liberty, but another is parliamentary privilege. And therefore, a parliamentary inquiry into all of this, and I hope the Honourable Member for Bromley and Chislehurst will read the Hansard of me saying this, would be very valuable into legal intimidation, into slaps, and it would also have the added advantage of giving key figures like Ms Leslie, who I didn't serve with, but I know most of the members in this committee did, the opportunity to come to this House and say things that are true, but she is worried of saying any other place because she is frightened of losing her home and all the other things that were described in the excellent opening speech by my right honourable friend. Yes, I will.
I think he makes a very important point on whistleblowers. Whistleblowers get privilege if they give evidence to a parliamentary committee. But the act of coming to give evidence is not necessarily privileged, and they could face legal action for choosing to reveal information. Do you think we should look seriously at the idea of extending privilege so that any whistleblower invited to come to a parliamentary committee will be protected in the act of giving evidence?
I thank my right honourable friend who speaks with experience as a former chair of a select committee, and I know the procedure committee on which I sit has been looking at what is covered by parliamentary privilege, and I'm sure my right honourable friend, the member for Staffordshire Moorlands, will make sure she hears what he has said today and whether that is something we could look at. Yes.
I'll just say the use of privilege is, occasionally we get it wrong and everyone talks about abusing it, but actually it's fundamentally so important, and actually we need to update it. We need absolute clarity on committees, we need absolute clarity on broadcast, we need absolute clarity on the relationship of staying here, talking about things here and being able to discuss them outside. That is something that urgently needs to be looked at, and if we need new Prime Minister's legislation, let's get it. But please, if you'd keep on looking at it, we'd all be very grateful. Thank you.
I thank my right honourable friend for his intervention, and one more.
on exactly this point, because one of the things that came up when we were discussing the strategy of this debate was the whole question of other people using subject access requests on this House. And of course the advice the House authorities give is that you should respond to subject access requests. So I told my office, no you don't, I'll go to prison before you give away any information on the debating of things in this House. And I think we need to update those rules too, so that we are actually properly protected in future.
I thank you, Madam Deputy Speaker, and I thank my right honourable friend for that intervention, and I will ensure that all three of those interventions are brought to the attention of the Procedure Committee, because I think there is a lot to consider here, and it is worrying that those tools could be used against members of Parliament who, in many ways, we should have full protections in all aspects of our job, not just what we say in this chamber. One more time, go on.
Just on that point as well, I know from my experience formerly chairing the DCMS committee, is that committee clerks and staff of the House are often sent repeated requests for information on data they hold for them. Some of it is exempt, if it's the main business committee, some of it is not, and a huge amount of clerks' time and committee time is taken up processing these requests.
Yes, I quite understand the point, the position clerks are in, and of course our staffers can be in that position as well, and we need to have protections for everything that goes on in this place and around this place in the proper exercise of our duties. What else do we need, as well as things we can do in Parliament? I think fundamentally we need a change of the legal rulebook. Many of the tactics that are deployed by unscrupulous claimants are becoming, in fact, so increasingly commonplace as to constitute a rulebook of tactics and strategies to thwart corruption investigations. And this needs to be countered by an opposing rulebook in the ways that people have said. Anti-SLAPP laws, a reorientation of the legal profession and the private investigation and PR firms to abide by fair standards of litigation in order to stop pre-trial manoeuvres which are designed to just simply drain resources and intimidate counterparties. And such reorientation would involve an overhaul of all the regulations applicable to the legal profession in the conduct of litigation. And as many have said, the legal professional bodies need to look hard about what they're permitting to take place under their auspices. So let's look at those anti-SLAPP laws. Let's look at what happens elsewhere. As the member for Birmingham Hodge Hill mentioned, what happens in the USA with this public figure defence. You've got Protection of Public Participation Acts in Ontario 2015, similarly in the Australian Capital Territory in 2008. There are off-the-shelf models in other countries we can adapt to work in the United Kingdom. Now, my right honourable friend began by, to conclude, my right honourable friend began by praising our courts, and of course he's right to do so. But all the best infrastructure in the world, all of our best infrastructure, can always be abused. People can drive at 110 miles an hour on our motorways, and people can flush whatever they like into our sewers. We must not let dirty money flush through our courts. We must find a way to prevent the perversion of justice by people who mean us harm.
Yeah. Thank you. Oh, my goodness, that was quick. Richard Thompson.
Thank you, Madam Deputy Speaker. And could I begin by congratulating the Honourable Member for Halton Price and Howden for securing what has been a very important and fascinating and crucial debate, and also the Member for Birmingham Hodge Hill, who I see is not currently in his place, for the work that they did to bring this this debate to the House so quickly and persuade others to do that. And can I also say congratulate and thank the member for Poplar and Limehouse for sharing with us a very, very compelling personal testimony that she had about how she has personally been on the receiving end of many of the bullying tactics that we've heard in the House this afternoon. Now, Madam Deputy Speaker, what's run through like a golden thread through this discussion all afternoon is that freedom of expression is one of our core values, that you should have the freedom to be able to say what you think, to be able to share information and to share ideas and to challenge received wisdom and to also to challenge the behaviour of others. But it does not come as an unalloyed freedom. We place limits on freedom of expression so that people are not entirely free of the consequences of that freedom of expression, and nor should they. And we also quite rightly allow through our legal systems to allow people recourse who have been defamed through the use of people's freedom of expression, so that redress may be sought appropriately. Now, it's often said quite cynically that the Ritz Hotel is open to all, just like the law courts, and obviously the truth in that is that yes, the law courts are open to all, but it can be ruinously expensive to resort to law, whether it's for some of our more routine transactions that we make across our lifetime, or indeed when it comes to going to court to seek a remedy for defamation. And it's well beyond the reach of most people, and even if matters do not get to court. So, the Scottish courts have never, thankfully, been a very popular destination, Madam Deputy Speaker, for libel tourism, and doubtless there are many, many reasons for that, but I suspect that maybe the lower costs of some, I will emphasise some Scottish lawyers, and the lower awards that are often made in the course of defamation actions which are successful, that has no doubt played its own role in that. But unfortunately, as we've heard, the same cannot be said for the courts in England, which are increasingly the venue for these David and Goliath struggles and actions, or simply even the threats of actions, which allow the powerful and the wealthy, whether they're from the UK or whether they're from elsewhere in the world, to silence, to intimidate, to cow, to browbeat and otherwise silence anyone who's got something to say or information that they would like to share, or criticisms that they have to make which run counter to the influence, to the interests of those wealthy and powerful people. Now, London already has a highly unenviable reputation as being the laundrette for much of the world's dirty money, and through its burgeoning public relations and public affairs industry, the comparative accessibility of the courts to those with enough money and sufficient financial stamina to make use of them. It's also a city which is increasingly, sadly, becoming a laundrette for the sullied reputations of individuals and corporate entities as well. Now, I think it's all very well. The best courts are the ones which serve the population best in terms of their accessibility, their fairness of process, their transparency and the consistency and the justice of the outcome. And that's the sort of legal systems that we should be looking to ensure that we have, rather than simply having the best legal systems that money in this case can buy. Now, London is obviously a massive global centre for many things, for culture, for finance, for politics, for diplomacy, for business, for commerce. And wherever power, money and influence intersect, it's no surprise that attention is focused, that comment is focused on that people commentate on that they report on that they discuss that in the various public and private forums that we have. And it's important, above all, that should be that power and influence and passage of wealth should be scrutinised and held to account. As the member for Birmingham Hodge Hill said earlier about the actions of the Russian state, in particular from Ukraine to the Baltics, we're becoming increasingly, and even domestically, I would hope, we're becoming increasingly aware of the menace and the impact that there is of misinformation and disinformation, all of which aims to mislead and to anger and to influence values and ultimately to change behaviour. I don't have enough time this afternoon. It would be straying just a little bit off topic, but we might apply the same focus to party political funding in terms of how that is being used in order to change the nature of some of the debates that we're having and some of the democratic choices that go on to be made. But obviously the antidote to this is openness, it's truth, it's rule of law, and it's about having a free flow of information. And for the courts to be used as a venue for the vexatious, the speculative and the downright malicious use of the law to hinder that process of the free flow of information simply serves to harm legitimate business interests, it harms democracy, it harms our lives, and ultimately it harms the way that we are able to live our lives in the manner that we would otherwise choose. So that's why this is so important. Now, this afternoon, members have been able to use parliamentary privilege to highlight many examples of concern, and I think it was good and useful that was able to be done to help to illustrate for anyone who reads the proceedings or who has been watching to understand the pernicious nature of how the courts and the legal system is being used in order to silence and to intimidate and to cow and to otherwise get people to vacate the space of public discourse. But the UK Anti-SLAPP Coalition has a number of proposals. We've heard some of them mentioned in various members' speeches over the course of the debate, but I would just like to highlight three in particular. And the first of these seems to be fairly fundamental, that should there not, and I hope the Minister will address this point directly, should there not be an accelerated process put in place to dispose of SLAPPs at the earliest possible opportunity so that a judge can take an early decision on the merit or otherwise, and let's be honest, in most cases otherwise, of these kinds of actions. We should also be looking at what sanctions can be put in place to deter and delegitimise the use of SLAPPs in the courts. And also, there should be, and I wouldn't be overly prescriptive about this because this is just really the start of the debate, I think, we should be looking at what protective measures can be put in place in order to safeguard individuals and those who act as public watchdogs to protect them from SLAPPs and to ensure that where the legal process does advance, that they are able to fight back on something approximating to a level playing field. But this, Madam Deputy Speaker, in drawing my remarks to a close, I think while this backbench business debate has been a very, very useful and necessary opportunity to highlight this, it does require much, much more than what we've been able to say, each of us, this afternoon. So it needs much, much more than a backbench debate. It needs the government to act, and it needs the government to act in a way which sets aside all private interests while it is doing so.
Andy Slaughter.
Thank you very much, Madam Deputy Speaker, and thanks also to the Backbench Business Committee for granting this important debate. Can I first congratulate the Right Honourable Member for Howden Price and Howden on securing the debate and his excellent speech. He is rightly renowned as not only an advocate but a practitioner of free speech, as indeed we saw in the House yesterday. I should add very, very briefly on that subject that as he knows his history, perhaps better than the Prime Minister, he knows both Leo Amery and indeed Oliver Cromwell got the results they desired in short order with the departure of Chamberlain and the Rump Parliament, though we shouldn't stretch these analogies too far, Madam Deputy Speaker, because Cromwell required a company of musketeers to clear out the Rump, which including pulling the Speaker from his chair. Yes, and in any event, the Rump was back 6 years later, quickly followed by the restoration of the monarchy, which I don't think is what Cromwell had intended. Anyway, I digress slightly. Could I also, personally, but I'm sure I get to speak for a number of members on this side, send our solidarity to Charlotte Leslie, who I've worked with on Middle East matters and still do, even though she's no longer a member, and I wish her well and hope that she is successful in resisting the appalling bullying conduct against her. I'd also like to congratulate my honourable friend, the member for Birmingham Hodge Hill, as a co-sponsor of this debate, who's also been assiduous in raising this matter inside and outside Parliament. We've heard a lot of very passionate speeches this afternoon from the member for North Thanet and Eltham and the Isle of Wight, Newcastle under Lyme. But could I again particularly praise my honourable friend, member for Popular Limehouse, who made a difficult speech on a sensitive subject and raised not only important issues on relating to this debate and on domestic violence, but on other issues as well. One which I won't digress onto, because it's not a subject today, but I think it's important, is about the nature of prosecutors. Yeah. We saw that with the Horizon scandal in the post offices, and she makes the point again about prosecutors other than those, other than the CPS. She mentioned the role of the media, however, and the disproportionate power of the media, and I will address that because I think it's relevant to this debate in a moment. But let me first of all just say something in general about lawfare or SLAPs, strategic lawsuits against public participation, and try and avoid descending too much into jargon. But they're an increasing feature within the UK court system, or perhaps the English court system is a better way to put it, and they are an abuse of that system. Their intention is to silence legitimate interests, not by merit or argument, but by process and oppressive conduct. And they prevent journalists, investigators, and even regulatory bodies from shining light on issues of great public interest. Over the last few days, I've attended briefings from lawyers, investigators, and writers to hear about their first-hand experience of SLAPs, and I'm grateful for that. They allege that the English court system is being used to play out this tool of legal harassment. The purpose of this debate is to discuss the evidence for SLAPs and the reason they are prevalent in this jurisdiction. Is it that our legal system favours them, or that those who employ them are overrepresented in the UK? I think probably both. That said, we need to get the balance right. Freedom of speech is central to our values in the UK. The Lord Chancellor has made that clear in his proposed Bill of Rights. But inequality of arms and abusive conduct in litigation can work both ways. For every David sued by Goliath, every oligarch chasing an investigative reporter, there may be a tabloid newspaper willing to libel an innocent citizen, knowing they can neither afford the cost of bringing a claim nor the risk of losing one. So I'll be happy today if the Minister first acknowledges that we have a problem, and second undertakes to go and look for a solution. I don't have one that I think is bulletproof, and I don't immediately expect him to. On the other hand, I hope he won't bury his head in the sand and deny this is a substantial problem that is bringing our internationally revered justice system into disrepute. I doubt he will, having heard the compelling testimony of earlier speakers and the case histories they have presented. We've heard about the case of Tom Burgess and the Eurasian Natural Resources Corporation from several speakers. Since the publication of his book, Kleptopia, I have my copy here, and I'm afraid it is, so I haven't had time to get to Waterstones, borrowed from the House of Commons Library, but I have promised that I will go and buy a copy to at least even up the financial balance a little bit in that case. But Tom and his publishers, HarperCollins and the Financial Times, for which he writes, have been subjected to a torrent of litigation against them by the ENRC. The ENRC, as we've heard, are subject to an ongoing investigation by the Serious Fraud Office focused on allegations of bribery, fraud and corruption, which resulted in the procurement of mineral assets in the Democratic Republic of the Congo. But ENRC have not just brought a legal case against Tom Burgess and the Financial Times, they've also brought proceedings against the SFO. Now, I have my own quarrels with the SFO, as does the government. The Attorney General announced last year that she would investigate its mishandling of the Ziad Arkell case, though, as I found out from a parliamentary question this week, that investigation has yet to start. But many of the SFO's problems come from a lack of resources. ENRC spends as much on litigation in each year as the SFO's entire budget. And the fact that the ENRC feels so emboldened as to sue a UK government department when that same department is currently investigating them for bribery, fraud and corruption should concern the Minister. And I'll share with the House that I got an email about a week ago from a company called Riverside Advisory, who describe themselves as a private client communication service and reputation management company, who act on behalf of ENRC, asking if I wanted to meet them, I think because they believe I'm a member of the Select Committee still. So the chair of the Select Committee may have received, and I see he's in his place, and I commend his very learned speech as well here. He may have also received that, in which they wish to piggyback on the Select Committee's inquiry into fraud and the justice system to tell us about their exasperation at their treatment by the SFO, and that they filed a high-profile civil claim in the High Court last summer on an allegation of misfeasance in public office. And they've offered to brief me, so I might go and take that briefing up. Other members may want to come and join me, I don't know. But there it is. It is this inequality of arms that I would like to speak to next. SLAPs have several identifying features, but a common thread in all SLAP cases is the ability of the claimant to continue the lawsuit for many months, sometimes years, due to their enormous financial resources. The defendant then spends money trying to defend the action, which can prove financially ruinous, even if they win or win on most points. If they risk losing the case, the costs are such that it is tempting to concede at an early stage. And this self-censorship or chilling effect mean that we never hear about most SLAPs, let alone the information that has been suppressed. The disproportion also feeds into the number of claims filed against a person or organisation, and increasingly it is individuals that the claimants pursue, as we've heard, journalists rather than newspapers, and that gives a clue to their motivation. Why sue an impecunious writer rather than a media group? Because intimidation is more important than damages. Similarly, by bringing multiple proceedings, the claimant seeks to overwhelm the defendant. SLAPs are not a tool to set the record straight or to protect a previously unblemished reputation, but to silence public participation, to bully and halt public criticism. There is currently, as far as I'm aware, no judicial guidance or legislation expressly dealing with SLAP cases. Of course, English judges will take a robust line with parties they think abuse the court process. Just this week, the High Court threw out a 5-year-old negligence case for warehousing, that is, maintaining a suit while doing the bare minimum to progress the litigation. But that is a long way from the position in many US states that have specific anti-SLAP laws in place. London is already seen as friendly to SLAPs and the people who bring them. If other jurisdictions are being proactive in being anti-SLAP, even more actions will be commenced here. The Foreign Policy Centre surveyed 63 investigative journalists across 41 countries and found that the UK is the most frequent international country of origin for legal threats. I await the Minister telling us whether he recognises the problem and the scale of it, and any ideas he has to fix it. In particular, how we can rein in the oligarchs, their corporate vehicles and Rottweiler law firms, without further limiting the ability of genuine victims of press vilification and intrusion from getting justice. I fear that the government has a poor record on both points. The lurid stories of Tory donors that my honourable friend, Member for Hodge Hill, recounted in the election bill debates earlier this week suggests they're not ready to take on vested interests, and the shameful way they sidelined the recommendations of the Leveson inquiry, which sought to provide a low-cost litigation for claimants and defendants in media cases, prove they are not prepared to offend the media barons. But investigative journalists are a key component of a democratic society. That is why they are anathema to repressive regimes around the world. They risk their reputations, their assets, and sometimes their lives to expose corruption. All they ask from a government that purports to believe in free speech is to make the rules of the game fair. And it is not only writers and journalists, it's investigators and even public bodies, as we heard, that are being prevented from carrying out their functions. And it isn't only defamation suits, but privacy, data, and even judicial review claims that are being perverted to this end. There is more the government can do to protect people against SLAPs and ensure that freedom of speech and expression is not curtailed by an unelected, seriously wealthy few and their agents, including, shamefully, some of the best-known law firms in this country. We could start with clearer judicial guidance, and better regulation of the legal profession, and indeed measures to control costs. But we may need legislation. What we can't continue to do is nothing for the sake of victims of slaps, but also the court system in this country and the government's own reputation. Thank you, Madam Deputy Speaker.
Minister James Cartledge.
Thank you, Madam Deputy Speaker. And let me begin by giving my congratulations to the Right Honourable Member for Birmingham Hodge Hill and my Right Honourable friend, the Member for Alton Price and Howden, for bringing forward this very important debate. And I congratulate the Backbench Business Committee because it has raised the profile of this very important subject, and I recognise that. If I may just make two points about the ruling on sub judice, Madam Deputy Speaker. The first is that as the Minister for the Courts in the Ministry of Justice, I still would not want to comment on any live or recent cases for obvious reasons, and that would include the case referred to by the Honourable Lady, her case, the Honourable Lady for Poplar and Limehouse, that I pay, like the front bench folks of the SNP, I pay tribute to her bravery and courage in talking as she did on her experience of domestic abuse. The other point concerns the 17th century, Madam Deputy Speaker, where the Honourable Gentleman opposite, the shadow spokesman, was lingering briefly. And of course, the Bill of Rights, Article 9 of Bill of Rights, 1689, we are all incredibly privileged. My honourable friend, the member for Newcastle-under-Lyme, made this point, to have the right to stand up in this House under parliamentary privilege, knowing that we cannot be taken to court for what is said, because what that means is that we all enjoy the freedom to speak out without fear of those powers, those rich people that we've been talking about. And I do think it's important that we've therefore been able to put this on record. It shows Parliament at its best when we have these sorts of debates with colleagues showing what I think is a consensus on these matters and speaking with great passion. And I do pay tribute to all the speeches we've heard today, Madam Deputy Speaker. So let me set out our position. I think all of us can be proud of the respect that the UK judiciary and legal profession attracts around the globe. One of this country's great exports is the common law system and rule of law principles, which are fundamental aspects of our constitutional arrangement. My honourable friend for the Isle of Wight spoke about the value of legal services. He's absolutely right. In 2019, the sector contributed over £29.6 billion gross value added to the economy and generated revenue of over £36 billion. That's many jobs in our constituencies. Key to the proper functioning of the courts, though, and to the law is transparency and integrity. These values underpin public scrutiny of the powerful and maintain confidence in our laws. But let me be clear. Today's speakers are right to highlight the rare instances where the law is being weaponised as lawfare. Slaps represent an abuse of the legal system. Let me be clear about that, as they rely upon threatening tactics to silence free speech advocates who act in the public interest. Public participation enriches all our lives and our democracy. Having said that, I agree with my right honourable friend for Alton Price and Howden. I think towards the end of his speech he spoke about the question of balance. We do have to approach this in a balanced way. We must be cautious to respond to slaps in a proportionate way that continues our tradition, Madam Deputy Speaker, of balancing individual rights with the public good. So let me talk about actions we have taken and are taking at home and abroad in this area. I want to reassure this House of the government's commitment to act whenever the rule of law is under attack. We acted decisively in 2013 to introduce reforms to the Defamation Act to curb the practice of what's called libel tourism, which had allowed a number of overseas claimants to use our courts to challenge publications with small circulations in this country. A number of colleagues, including the Right Honourable Member for Hodge Hill, spoke about how, if you like, England, London in particular, had become a centre for international libel. But under Section 9 of that Act, the courts must now be satisfied that England and Wales is the most appropriate jurisdiction in which to hear a claim. The courts have robustly interpreted this test, notably in the Court of Appeal case Wright versus Ver. Now, whilst these reforms have succeeded in tempering international libel litigation in the UK, we are now exploring further whether further reform may be necessary when litigation targets public participation specifically. I note that according to the Royal Courts of Justice most recent statistics, defamation cases in the High Court in 2020 were in line with the average number for the past decade of 152. This suggests that we must not be premature in launching a response to slaps, but instead grow our evidence base through careful monitoring as Lord Wolfson undertook to do in the House of Lords last June. My ministerial colleague in the Department of Justice. I want to commend the UK's anti-SLAPP coalition for their support and advocacy in this field. Ministry of Justice officials are monitoring anti-SLAPP efforts in neighbouring nations. This is a fast-evolving jurisdiction which nonetheless warrants a considered response. A core feature of any democracy must be open justice and free speech. The Ministry of Justice recently launched the Bill of Rights consultation with an explicit aim to strengthen protection of the key British value of free speech. Our proposals intend to provide statutory guidance to the courts on the utmost importance attached to the right to freedom of expression. This is particularly important when considering whether an interference with the right to freedom of expression is proportionate for the protection of the rights and freedoms of others when set against the wider public interest. The right to freedom of expression is protected by Article 10 of the European Convention on Human Rights, which is given effect in domestic courts by the Human Rights Act 1998. We are signatories to the ECHR, and I can assure colleagues we will remain so. Our proposals for a Bill of Rights will go even further to promote this country's proud tradition of freedom and reinforce the democratic prerogatives of elected members in this House over the legislative process in respect of the expansion of human rights. Now, it must be said that free expression is not an absolute right. There is a delicate interplay between the need to protect security, the right to a private life, keeping citizens safe, and taking steps to protect against harm to individuals. The ongoing rights consultation, our human rights consultation, closes in March 22, after which we will set out detailed plans to reinforce our great tradition of free speech. A number of colleagues have spoken about investigative journalism. We recognise this plays an important part, keeping us all informed and promoting accountability where there is wrongdoing. Officials from my department are monitoring threats against journalists in the form of SLAPPs, working closely with civil society stakeholders who tirelessly support journalists under threat to understand the immense financial and psychological burden that a few have endured when faced with these actions. Where journalists face physical threats, the Department for Culture, Media and Sport's National Action Plan for the Safety of Journalists exists to support their security and well-being. But we are not alone in combating SLAPPs. The Ministry of Justice is collaborating with the Foreign, Commonwealth and Development Office to ensure a united stance on international engagement and media freedom around the world. I am pleased to announce that the UK will be a member of the Council of Europe's inaugural working group on SLAPPs, thanks to our diplomatic collaboration. The working group is comprised of experts in law and media policy who will begin working this year on an anti-SLAPP draft recommendation for Member States due in December 2023. We have also met the Organisation for Security and Cooperation in Europe's representatives on Freedom of the Media team to discuss common objectives in addressing SLAPPs. Meanwhile, the Media Freedom Coalition continues to expand since its foundation in 2019 and consists of 50 members who have pledged to improve media freedom at home and abroad. It has also issued 20 statements on the deteriorating situations for media freedom concerns in various countries, including in Yemen, the Philippines, Belarus, Egypt, China, Hong Kong, Myanmar and Russia. This government recognises that global media freedom increases security and prosperity for all, which is why this was a cornerstone of our G7 presidency. Misinformation can undermine public order and even health, particularly during the COVID-19 pandemic. To this end, the UK has supported UNESCO's Global Media Defence Fund, committing £3 million over 5 years and encouraging contributions from others. Further, the UK has provided over £400 million in official development assistance to media and free flow of information in the past 5 years. We are consistently in the top 5 aid donors to the media sector globally. Madam Deputy Speaker, I recognise the strength of feeling in the House today, given the importance of principles at play. In light of evidence provided in today's debate, I will be giving SLAPPs in UK courts urgent consideration. Of course, give way to...
I'm grateful for the Minister giving way. I've been here purely to listen to the debate, but one question I would like to put to him: does he accept that both government and opposition parties are targets for systematic attempts to buy political influence? And if so, does he accept that those people who are trying to check the legitimacy of such donations must be properly protected?
Well, my honourable friend, who's had a track record in scrutinising these matters, makes a very good point. I would simply say one thing, because the opposition spokesman did mention donations to our party. But I think all of us should be concerned about recent stories about certain donations from an individual connected with the Chinese Communist Party to a member of this House. I will so as I said, Madam Speaker, I will be giving slaps in UK courts urgent consideration. I want to make it clear that this government is... Let me just finish this point. Is committed to a robust defence of transparency and freedom of speech. We will not tolerate anything that risks tarnishing the integrity of our judicial and legal profession. I'll have to give... Wait,
I'm sorry to come back, but I really thought that wasn't a reply to my intervention. I made it quite clear at the beginning that both parties on both sides of the House are subject to this problem. What I'm looking for is a commitment from the government that when people are trying to do due diligence and check on behalf of their parties or any other organisations within their parties that donations are legitimate, the government will recognise the need for such people to be protected and not to be sued when they're trying to see whether or not the donation is clean money or dirty money. Now, will he give a straightforward answer to that question?
Let me just be clear, my friend. I was simply referring to taking the debate as a whole. I recognise he referred to both, all parties. I was just putting some balance in the fact that we'd only heard from one party. In terms of his point, I'm more than happy to meet with him and look into the detail of what he proposes, because I don't think it is directly relevant to the matters we've been debating today. It is important to consider lawfare threats in the broader context of government action to curb abusive foreign influence. I'll just quickly say, last year the Department for Business, Energy and Industrial Strategy brought in the National Security and Investment Act 2021 precisely to target foreign state interference in our economy. Now, I will give way.
And I'm grateful for him for listening to this debate. When he says it wasn't directly relevant, with great respect it was, because we need to be protecting people like Charlotte and Leslie who are trying to do due diligence. We need to be protecting officials at the FSO to make sure they are not hounded individually. We need to be protecting journalists. We need to be protecting people here. We need to be protecting quite a lot of people in this debate. And he says that, you're going to do everything, the government is going to do everything in its power. That's great, but actually we need to get on an act, because there is a real specific problem at the moment.
Okay, I recognise that there is a lot of concern about sources of money. In terms of the debate itself, the Honourable Gentleman for Eltham and a number of other colleagues have talked about the source of funding. I do recognise the importance of this, and I just want to stress the legal profession has robust due diligence mechanisms in place to prevent dirty money corrupting our courts. Anti-money laundering regulations exist to combat illicit financing. The suspicious activity reporting regime requires legal professions to report to the UK Financial Intelligence Unit within the National Crime Agency where terrorist activity or money laundering is suspected. Law enforcement officials must act safe in the knowledge that the government defends their investigative remit, as we all collectively rely on their industry. There's been a lot of talk about follow the money. I just make the point that we do have robust regulations in place, as my honourable friend, the chair of the Justice Select Committee earlier, and my last one, I'll give way to the former Lord Chancellor.
I'm extremely grateful to my honourable friend. I know he's working very hard on these issues. He's right to talk about SARs. The problem with SARs is that we have far too long prioritised quantity over quality. And will he absolutely focus together with his colleagues in the Home Office to make sure that actually we make this a meaningful process? And can I just gently not chide him, but just say that actually the point made by my right honourable friend, the member for New Forest East, is germane. It is a clear slap if you have somebody trying to do the right thing in the public interest, and then you get a litigation in effect that stops that. That is a classic slap, and that is indeed something that we should all be concerned about.
I certainly recognise the expertise of my honourable friend, and I apologise to my colleague from New Forest if I misinterpreted his question. I was seeing it perhaps in a different context, and perhaps I didn't want to
mention Charlotte Leslie specifically, but that we had spent plenty of time hearing about the Charlotte Leslie case, and I will now mention her specifically. The fact is, she was trying to see whether or not the money that was being offered by someone who wanted to take over a political organisation within the Conservative Party was clean or dirty. And as a result of her doing her duty, she is threatened with financial ruin. And if my honourable friend, the Minister, cannot see the relevance of my asking for protection for such people to this debate, then he needs to go back and restudy his brief. I'm sorry to put it in those terms, but I can't put it in any other way.
Respond to the intervention first. Let me just answer, because it is an important point. I said at the beginning that I would not comment on specific cases, no matter how
Order. We will be very careful about specific cases. I understand the point that the honourable gentleman is making. The Minister is being rightly careful, and there are perhaps some discussions which might better take place not here in the glare of publicity. Minister.
I'm going to come to what I think one of the most important points, my final, if you like, substantive point. It's about cost, because the Honourable Gentleman from the Isle of Wight and a number of other colleagues have talked about the way in which costs are used. I think his words was to financially destroy people, journalists, etc. And I just want to talk about this because, as has been made clear, SLAPs often threaten journalists with ruinous cost claims. In recent years, civil litigation costs, including defamation, have been subject to greater control. The government commenced the no-win, no-fee conditional fee agreement, the CFA reforms, in Part 2 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012 for defamation and privacy cases. This meant the lawyer's success fee was no longer payable by the losing party. This further controls the costs of these cases and gave effect to our legal obligations under MGN versus UK judgment of the European Court of Human Rights in 2012. We are keeping the existing cost protection regime in place for the time being. This means that after the event, insurance premiums are recoverable for defamation and privacy cases as the CFA reforms are enforced. The ATE regime enables parties with a good case to litigate and discharge their Article 10 rights for freedom of expression without the fear of having to pay potentially ruinous legal costs if their case fails. This approach controls costs but protects access to justice, since parties with good cases can still benefit from recoverable ATE insurance in respect of adverse cost. We also introduced a rule which means that costs which are disproportionate will not be recoverable even when they are reasonably or necessarily incurred. The rule is intended to control the costs of activity that is clearly disproportionate to the value, complexity and importance of the claim, as is the case in SLAPs. But let me be absolutely clear. If more action is needed, I am happy to look at it. I said I do recognise that this is a really important issue. I think Sorry, I thought it was another phantom intervention. I do apologise. I'm going to wind up. This country will always support vigorous debate here and abroad. Indeed, our rule of law requires it. Where we see proof that foreign sources seek to undermine our values using the law against our national interest, the government is poised to act. I ask today's speakers to work with us as we consider the full suite of legislative and regulatory reforms available to stop lawfare on our soil. This debate has had an impact, and we will respond. Grateful to all speakers for taking part, and thank you, Madam Deputy Speaker.
David Davis.
Thank you, Madam Deputy Speaker. I have to say, before we started, I did not necessarily expect this to be a particular success, this debate today, because it deals with an industry that hides evil in plain sight. And so it's pretty difficult to deal with something that can hide evil in plain sight. And yet we have had a formidably effective debate, whether it's at the detail level of the Honourable Member for the Isle of Wight giving us astonishing insights into how the Russians operate, through the Honourable Member for my honourable friend for Newcastle under Lyme on his localised issue, or the courageous, I have to say, courageous exposition of the Honourable Lady for Poplar and Limehouse of what happened to her. All those things demonstrate how these impact on ordinary people, the simple people we aim to represent. And at a grander level, I hope you'll forgive me for saying it, that was the best speech I've ever heard the Right Honourable Member for Hodge Hill give today. It was formidable, passionate, and went right to the point. And it was picked up, of course, by my honourable friend for Thanet North in terms of talking of the kleptosphere and how we have to deal with that. But if I can come to the substance of what we're talking about, I mean, the opposition spokesman, the member for Gordon, said quite rightly this needs much more than a backbench debate. There's no two ways about it, and it's difficult. It's going to be difficult. The member for Hammersmith, quite rightly, I think he crystallised the whole thing. We need to make the rules of the game fair in a game where one side has enormous resources and the other side doesn't. And even measured against the resources of government, we have to think whether or not we're putting enough effort into it. These people have spent, these are the people that my honourable friend, the member for the Isle of Wight made clear. They made an industry out of devising incredibly complex tactics to exploit the HRA. Not just, they use all of the articles one against the other. And so, if I say this to him, I welcomed what he said about recognising this, but I think the difficulty he had answering the question from the chairman of the ISC demonstrated the complexity and detailed nature of these problems. So please, I say to him, do not rely simply on the consultation with the Bill of Rights legislation or whatever. The sophistication of this requires a special look. It requires careful attention. And of course, the huge authority of the day was the chairman of the Justice Committee. And I'm going to simplify everything he said, which was basically a tutorial for all of us, down to the last point he made. And that is, we can pick the best of the anti-SLAPP legislation in the States and other places. And that's the way to go. We have to start with a proper, detailed, tight investigation and deliver off the back of the best practice elsewhere. And that's my request to the Minister today. He's done a sterling job of dealing with a really difficult issue, and I hope he'll carry on in that direction.
Yeah.
I think the honourable gentleman has already spoken, but he has the leave of the House to speak again.
This has been one of the most remarkable debates I've sat through, Madam Deputy Speaker, in 18 years at the House. This is an extremely serious issue. There's been a high level of cross-party consensus, and there's been immense practical detail offered today. I've been in the Minister's position when there is turbulence at the top. I urge him to keep his head down and plough on. We cannot afford anything less. Madam Deputy Speaker, it was 32 years ago President Gorbachev came to the Council of Europe and talked about his dream of a common European home and a single legal space, our great gift to the world. That dream is now shattered, but that means that we have a special obligation here in this country, as the home of the Magna Carta and the Bill of Rights, to be a beacon and a champion of freedom, rights and free speech, and that's the challenge to which he must now rise.
I'm glad the honourable gentleman had the leave of the House to speak again. The question is, as on the order paper. As members of that opinion say aye. Aye. To the contrary, no. The ayes have it. The ayes have it.
I beg to move this House to now adjourn.
The question